Well, good morning, everyone. Welcome to hearing number 8 of Variation 1. And this is the second to last hearing of a very long process, so we're nearly there. And at this stage, we're hearing from submitters regarding rezoning proposals in Lincoln. And just before I turn to our first submitter from the 42A reporting team, anything for us this morning? No. All right. We may have questions of you as we go along. Particularly, we requested some additional reporting from you, but we'll just, if we have any questions, we'll put them to you as the hearing proceeds. So, foodstuffs, good morning and welcome.
Good morning, kia ora. Thank you.
And you've prepared for us before, so you understand our process. We've read all the pre-circulated material, including your legal submissions, so you don't need to read any of that out loud to us, but yourself and your witnesses, of course, are very welcome to highlight key points for us or provide summaries for us, and then we'll see if we have questions.
Thank you, Commissioner. And in terms of the experts today, they will just be available for questions and they will deal upfront with any additional bits arising from the 42A report. In particular, there was a recommendation in terms of a pedestrian link that will be addressed upfront. I was just going to ask you, just before I start on legal, if you had any questions for Mr. Colgrave. He was intending to appear by Zoom if needed, but he's anticipating because of the agreement between the experts that won't be necessary.
I have no questions for Mr. Colgrave. Do you, Raymond?
No.
And Andrew? No, we have no questions for Mr. Colgrave, so he can get on with his day.
Thank you. So in terms of legals, I was just going to address a couple of matters up front. You've obviously got the legal submissions before you and you've read them, as you've said. So just touching upon whether the foodstuffs further submission within scope of Ag Research's submission. So I just want to highlight a few points there. Whether this is material to this process in terms of whether it needs to be in scope or not, and then whether the request itself is on the variation. So I've largely addressed it in the legal submissions, but I guess the points I wanted to make was when you look at the Ag Research submission, it's clear that it applies to the entire site. So the bit that Foodstuff's talking about is within that site that the Ag Research submission made a submission on. And I'd have set out at Appendix 2, which you would have read in terms of what was sought in terms of the balance area of that site being retained, or it could be rezoned to a neighbourhood centre zone. And also they've referred to in their attachment that the ODP has been drafted on the basis that the special purpose zone will be retained, but should alternative zoning options be considered appropriate, consequential amendments to the ODP would be required. So I think the point there is it's very clear through that submission, albeit perhaps the word confused might be appropriate at times throughout the submission. It's very clear that there was an intention to have some sort of commercial on that site. It wasn't clear where that would be or how that would look. The question is could it be anticipated that it was anticipated to be an extension to a supermarket? Maybe not. It could have been a centre. But in terms of the materiality of that, because you've got broader powers through this process of considering outside scope submissions, we're focused rather instead of would anyone be impacted by this? And because of the nature of the submission and because of what it's sought, and because there was no interest in that, and because there's been neighbouring properties also seeking commercial with no public interest, I think it's reasonable to conclude that although it may not have been entirely clear that we were seeking to extend the supermarket through that first submission, that there wouldn't be anyone who would have been an active submitter should that have been made clear in that first submission. So I think they are the kind of key points that I want to make in terms of whether it's on the submission. And talking about whether something's on a submission, we've obviously got a line of case law which talks about whether something's on, and that's sort of what we call the orthodox case law. In this process, it's slightly different. We've got one streamlined case in Auckland called Albany Landowners, which looks at, I guess, a streamlined process and that orthodox principles about whether something's on. And then we're different again from that situation, because with the Auckland unitary plan situation, the direction that the panel had in that instance was that the plan needed to be put together. So it was, they were turning into a unitary plan. They had to bring together the regional policy statement, a whole lot of different plans and mash it all together. So it's a very broad exercise where the panel in that instance also had discretion to, or people had appeal rights if it was considered to be outside scope. They could appeal that to the Environment Court. So there was, I guess, that fallback position of if you did take a narrower scope position, that there would be a remedy for people in that process. This process here is quite unique. I don't think it is directly comparable to any of the situations we've had before in that case law. And so while this particular situation, I think, does fall quite squarely within that orthodox principle, and that it's an extension to an existing zone, and you've got powers to obviously extend existing town centre areas, and the town centre area was notified as being under consideration. I do also think that you have to be mindful that we are in a process which requires some flexibility in thinking. You've got a legislative direction from the government to look at housing supply and how that housing supply needs to be increased. And with that increase in housing supply requires obviously an increase in some commercial services to service those people. Just because the council haven't notified commercial zones, it doesn't mean that's necessarily the right position, and perhaps they should have, to service that growing population. So while in this situation we're definitely, I think, squarely on the plan change, I also would urge that we do think more flexibly and in mind of the directions and what's required under the IPI to ensure that we're getting really good outcomes in terms of the well-functioning urban environment objectives that we're putting into the plan. Yeah, that's all I had to say. I've otherwise addressed everything in my legal submissions.
Thanks, Mr. Chair. So just querying just for my own clarity, I think. So you've said that the original submission covers the site. And I just want to be clear. So when I looked at the ODP, it looked like it wasn't in, the site was excluded from the ODP, and the submission says as set out on our ODP. So you're saying it was in the ODP or it wasn't in the ODP?
So the site that we're talking about wasn't in the ODP, but it was in the broader submission. So I've just referred to Appendix 2, which talks about seeking a new ODP for the Springs Road site. And it says, note, the ODP has been drafted on the basis that the special purpose knowledge zone would be retained over part of the site. Should alternative zoning options be considered appropriate, consequential amendments to the ODP would be required. And within the body of the submission, it talked about having a neighbourhood centre zone or another alternative zone.
Yeah. But wasn't the neighbourhood centre zone within the boundaries of the ODP?
It was within the boundaries of the site.
Wasn't the ODP? And because I mean I can understand
the ODP looks like it's just
within the ODP.
The ODP looks like it applies purely to the residential elements that's requested.
In the NOS as well, though, isn't it?
Yeah, I mean, I think where I've got to on this is I think the submission is confused at times. Obviously, it says within the site. Because what you would be left with if you're strictly reading the submission as you are, with only within the ODP, is you're left with a portion of their site not being rezoned.
Yes, I did wonder why that site was excluded from the ODP, but I just assumed it was just purposeful.
No, well, I obviously can't answer that question. Yeah.
And so your comment on, I think you talk about reason would consider the member of the public would not have become an active submitter if they had appreciated the change at the site. So that comment, is that about the change from neighbourhood centre zone to town centre zone, or is it also about the fact that it was uncertain whether the site was in or out, or both? Basically. So
the comment, I think, is it's clear when they're talking about in their submission, they're talking about the whole site. And I mean, if you've been to the site and you look at the ag research, you would look at the site as a whole. You wouldn't consider any part of that to be removed if you're a general member of the public. It's quite clear that that's the ag research site. So whether an element of that is commercial, which element with that wasn't clear, but it was clear in the submission that they were seeking the alternative of a commercial element, and that was summarised in the furthest in the summary of submissions that was notified to the public. So the point I'm making there is a public was aware that there could be some commercial on that site.
Yes.
Yeah, but not necessarily where that was. But I think if you were genuinely interested in that, you would have been alert to that and made a submission.
Okay. And I guess my final question is just around, I understand that the council can create new zones, non-residential zones, but doesn't that also have to end up still being within the context of giving effect to the MPSUD policy 3, which is about densities and heights, isn't it? Of commercial area, of within and adjacent to commercial areas.
Yeah, I think the way you would look at, so if you're exercising your powers under creating a new zone, you're not looking at whether you're adjacent to, you're looking at creating a new zone and then considering that policy 3D in the context of that new zone. So if you're putting a new zone somewhere, it's got to be commensurate with the area around it. If you read that policy as only applying to being adjacent, it wouldn't make any sense.
I think it says within as well, within and adjacent to town centres. But it was more just querying, isn't it more about the actual density of development within those locations rather than creating or extending a town centre? I
think if you're considering the functions under just the subsection 1, which is looking at policy 3D, and then obviously if you look under section 77N2, which talks about changing those provisions, then that is talking about changing those provisions for the purposes of density. When you've got to your third element of either extending that zone or creating a new zone, you're looking at providing for a better, well-functioning environment, providing that commercial centre commensurate to the residential activity. I don't think it needs to be adjacent or within in that context.
Right. So you're arguing that it's very broad in the application of the MDRS and implementation of policy 3 through this IPI process. We can actually relook at a number of rezonings generally and a number of other changes.
Yes, and a number of councils have done that quite specifically in the exercises up front. This council has notified that they were looking at that exercise and then made a call in their section 32 report not to have made those changes. We're saying that they should have in this instance for this site. Yeah.
Okay. All right, thank you. No further questions.
Just a comment first of all, and you refer to it in your legal submissions, our powers under clause 99(2)(b) of schedule 1 to make recommendations to the council that are outside the scope as long as it relates to a matter identified by either ourselves or another person during the hearing. So we haven't discussed this as a panel yet, but I'm comfortable that should we find in favour of what you put before us on the merits, that we certainly have ability under section 9(2)(b) to make that recommendation to the council. So I guess what I'm saying there, I don't think we need to get overly forensic on the scope issue in this case if we find in favour on the merits.
I agree with you, Commissioner, and that's why I took the approach I did in my submissions, focusing purely on those matters as opposed to scope. But I did want to say that there was, I guess it leans towards whether someone would be affected as the relevance of that submission. If that submission had not referred to commercial at all, I think we'd be in quite a different situation to what we're in today.
Yeah, I understand that. Yeah, you mentioned that there's probably, and then as far as I can tell from what I've read, my colleagues may have a different view than in terms of the merits. There's probably only one outstanding issue, and that's of the staff's recommended pedestrian cycling link to the land to the west.
Correct, and that was my reading.
You were going to talk to us about that?
Yes, it sounds like everyone's got agreement on that, and it's a rather easy extension of what's already been included as part of the ODP, but I will revert to the experts to address you on that directly.
Okay. So which expert would that be?
Is that going to be you, Mr. Allen? Yeah, Mr. Allen. Mr. Allen, planning.
Oh, yeah. Okay.
He's had input from all experts.
Yeah. And so what I have in front of me is the joint witness statement that came out of the conferencing between the staff and ag research people, and attached to that is an ODP for the ag research proposal. And so that's, if Mr. Allen is able to refer to that, because that already has some.
I understand that's what he started with as a base. So that, and I'm wondering whether we go out of turn here and just get Mr. Allen up.
Yeah, why not?
Speaking to that, if that's all right.
Yeah. So Mr. Allen, if you've got that JWS in front of you.
Yes, I do.
And I'm looking at what I call the ODP diagram. And can you just hold it up to make sure you've got the same one I've got? Yeah, that's the one. So if you look on that diagram, there's up near Gerald Street, there's a grey NOS zone.
Yes.
And there's a green dotted line, which I think is an indicative pedestrian cycle route. So would that green dotted line just carry on into the site that we're now looking at?
That's right. There's a plan that's coming around with showing exactly that.
Good.
2 or 3 additional green dots.
Yeah. Okay. Great.
So I discussed this with Mr. Jones yesterday. He'll obviously be able to speak to that for ag research. It's also had the input of the relevant transport and urban design experts for ag research and foodstuffs.
Yep.
So it's the extension to that boundary and also the addition of that green dotted circle indicative connection.
Great. No, that's all I wanted to ask about. And so I guess either yourself or the ag research people will be providing us with a word copy of that.
Certainly.
Yep.
Yes.
All right, now that's all I wanted to ask arising from the legal submissions.
No, this one here, did you hand that out?
Yeah, that one, yeah.
Okay, and just the second plan that got handed out as well, that's the precinct 5 plan.
Yeah.
So it was obviously, well, it was in my own evidence, but also a recommendation from the addendum report that plan be amended as well. So that's simply showing the additional TCZ zone land at the end, western end, and the extension of the ODP or the CAC boundary.
Yeah, no, that's helpful. Thank you.
Thank you. Did you have any other questions for Mr. Allen while he's here?
Well, let's just see. Any other questions from Mr. Allen? Rowe? Okay, good.
And I'm not sure, sorry, I'm not sure, Mr. Allen, if this question is for you, but so the capacity is an extra 1,000 square meters with the extension area.
That's right, yes.
How long would that future-proof the supermarket?
Yes, perhaps not the question for me.
We can get Mr. Parrish.
Ms.
to answer
Parrish,
that.
yes.
Yeah, all good. I'll save that for Ms. Parrish then, thank you. No.
No, that's all we had for you. Thank you.
Thank you. Mr. Smith? Where is he? Can you come up? Again, we're just intending to make Mr. Smith available for questions.
Good morning.
When they determine car parks, what method do they use? Because I find the car parks are never wide enough.
That's often the case. Yes, there are standards within the district plan in terms of the width of car parks, as well as the length and also aisle width for manoeuvring as well. And they essentially provide minimum standards for those dimensions. So we have adhered to those. It's an interesting challenge because you know, as time goes on, vehicles seem to be getting larger as well. But yeah, we've basically taken a lead from the district plan standards.
Okay, thank you.
Thank you, Ms.
Lovely, thank you so much.
Smith.
Good morning. Just remind me who you are again, sorry.
Yeah, like I'm Tony Milne, landscape and visual and a bit of urban design on the site. That's all right. Happy to answer any questions if you have any.
Mr. Mill?
No.
Andrew? No, me neither.
So easy.
I should just say Mr. Milne had input into the pedestrian connection, obviously, and
Yes.
ensuring appropriate
Yeah.
environment. And just Ms. Parrish, perhaps to front foot the question, Ms. Parrish, about capacity.
I haven't got such a wild introduction. I'm just Rebecca. Future-proofing supermarket in terms of the 1,000 square metre clip-on. we anticipate with the growth rates of Lincoln and in the surrounding area that would capture a supermarket customer base would be in the realms of 10 to 15 years. Yep. We built, so Lincoln began with a grocery introduction with the 4 Square, which was in the middle of the town centre, and with the growth rates post-earthquake, the new building was 1,700 square metres, and then we placed a 1,000 square metre clip-on onto the side of that to bring it up to 2,700. And then with this additional 1,000 square metre clip-on, what it does is it increases the food hall. So that's where you shop, where the customer can visually walk around the interior of the supermarket. So what our aim is to increase chilled and frozen and ambient within that what we call the food hall. So it's not an increase of back of house in terms of storage out the back or service facilities. It's what you can buy on the floor. And that's really important to match that with the growth rates of the catchment. Yeah, so we believe this provides Lincoln with a really strong grocery presence, and we're also mindful of Rolleston Pack and Save, which has that more regional catchment. So yeah, with the two together, that's a really strong presence, yeah, which would really satisfy the community.
And no questions from me either. Thank you.
Thank you. That concludes Foodstuff's case. I will have Mr. Allen email those plans through to the reporting officer.
Yep, right.
Or to the hearing.
Or both, to Vicky and to Heather.
And to myself. Okay, cool. Right.
So just, it's not really relevant to our determinations, but out of interest, if we were to find in favour of what you're asking us to do to extend the town centre zone over that parcel of land, how would that affect the resource consent application that you currently have lodged with the council? Does it have a material impact on that?
No, because I think by the time, I'm hoping by the time you've issued a decision, we would have a resource consent in hand. I'm not sure what the exact progress of that through the council, but because of the fact that we've got agreement with council as to the drain and the neighbouring landowners' approvals, it's anticipated to be non-notified and processed relatively quickly. I think what it would do is it would be the most efficient and effective means of administering that consent going forward and that construction of the building. Yeah, reflecting, I guess, the on the ground construction.
Sure. And just while we have you here in relation to last week's hearing, we've received your legal opinion on scope, so thanks for that. We're now just awaiting legal opinion from
council
solicitor. We've received, and once that's received, we'll look at that and undertake that process I described. If we think that there is scope, then we'll request conferencing to occur between the experts to see if there's any merits-based issues that need to be resolved.
And just anticipating if there is any issues arising, would I have the ability to reply to that? And the reason I request that is I have seen in another situation, in another process, of a very narrow position taken by a council lawyer as to scope, which in my view doesn't reflect what the sort of the legislative direction of the IPI and the differences between, say, the Albany landowners case. So if there is a very narrow position taken, am I able to reply in legal submission for that?
Wouldn't normally do that. Would normally take your position, which you've already told us about and documented for us, and the council solicitor's position. And if there's a difference, then we'll just have to make our mind up on that. Otherwise, then if we gave you another bite of the cherry, then we'd have to give the council solicitor
fair call. I'm sure there'll be no issues as the scope, so we won't need to worry about it.
It's very optimistic. But what I would give you the opportunity to do though, should we find in favour of the scope on that proposal, and if the various experts from the council and from Foodstuffs have areas of disagreement, then there may be an opportunity for you to come back with legal submissions on any merits-based areas of disagreement between the experts. But if we get to that stage, let's just see how that plays out.
Okay, no, thank you.
All right.
Appreciate it.
Thank you. All right, so that brings us to the end of that, and our next submitter wasn't scheduled until 10:30, but are you all here? Who are you waiting for? Thought I saw him here first thing in the morning. He was just out there before. From his car. Is that right? Mr. Who, sorry? Yeah. That's right. Look, that's fine. So we'll adjourn for now, and then when all your people have arrived, even if it's prior to, well, it's 10:45 you were scheduled for, sorry, 10:30 was the tea break. But if your team's in place before then, just let our hearing administrator know and we'll reconvene when you're all here. Yeah, good. Well, let's adjourn until then. And if everyone's here earlier, we'll start earlier. Yeah, thanks. In the hearing at this stage, we're hearing from Ag Research Limited. Good morning and welcome. You've appeared before us before, but I'll just repeat what I always say, just in case people are watching on YouTube. Thank you very much for providing the pre-circulated material, which we've read in full, including your legal submissions. Yourself and your witnesses don't need to read out loud to us anything that has been pre-circulated, but yourself and your witnesses are very welcome to either summarise or highlight key points for us, and then we'll see if we have questions.
Morning, thank you. So I have with me this morning Mr. Hickmott, who's the Director of Finance and Business Performance at Ag Research. So he hasn't appeared before Commissioner Willis before. He did attend the residential hearing briefly to sort of set the scene for the Ag Research case. So he's prepared just a few brief bullet points, which perhaps he could just take you through, and then we'll hear from the technical people. Perhaps before he does that, I don't have any particular aspects of my legal submissions to take you through. Just wanted to point out there that I also address, in addition to the rezoning sought, the further submission by Ag Research opposing a rezoning sought by others.
Sorry, I'm just going to interrupt you. I forgot to ask the reporting officers if they had anything to bring to our attention before we hear
yes.
from you. So that's my mistake. Sorry for that. So reporting team, anything you wish to
Yes.
bring to our attention before we hear from Sumida?
Yes, I do. So in the course of last week, Mr. Jones for Ag Research has circulated a draft land use rule to manage the Gerald Street Vernon Drive intersection upgrade.
Yeah.
So that was the outcome of the joint witness conferencing.
Yeah.
So I have been working through that with other council officers, and the one issue we have with it is it refers to no more than 100 residential units shall be occupied. And there's just some concern around the wording of occupied and how we actually administer that wording. So been working with the building consent team, and also it's contingent on some legal advice that council is also seeking at the moment in the subdivision space, because we're thinking we also need a subdivision rule to mirror the land use rule. So that is currently being worked through, but I don't have a final agreed version for the panel today, but just to let you know that that is occurring in the background.
Okay.
And I also have Ms. Wolfer with me here today, who can answer any questions relating to urban design and the linkages on the ODP.
All right. Thank you. So that legal advice you referred to, is that the legal advice the panel's requested regarding subdivision generally, or has council initiated some legal advice?
It's the same legal advice
Same legal
regarding the
advice.
activity status of subdivisions, yes.
Yeah, okay. All right, thank you. Sorry for that.
It's okay. So as you'll know, in terms of the Section 42A report on transport, servicing, geotechnical suitability, economics and land contamination, all of the experts are agreed. So on that basis, we don't have any of our experts other than Mr. Carr here to talk about those things. The other witnesses has to have conference, so you have the conferencing statements from them. So following that, there's no transport issues remaining in contention between Mr. Collins and Mr. Carr. Just the transport rule that needed to be drafted, which Mr. Jones can take you through that. Some of the urban design matters raised by Ms. Wolfer were resolved through agreed amendments to the ODP, and those amendments are included in the version of the ODP attached to the joint witness statement. And there's only really a small number of discrete urban design related issues remaining in contention. And those are really just two things: active transport connectivity within the ODP area, including the number and location of connections and the manner in which those are shown on the ODP. And then secondly, whether or not the living precinct for the knowledge zone over the balance of the ODP area is more appropriate than knowledge zone only. So Mr. Jones can talk you through that and his amended knowledge zone provisions, which in my opinion address all of the matters raised by Ms. Wolfer. In terms of the submission by Townsend and Co, I won't take you through my legal submissions in relation to that, but I addressed the case law on reverse sensitivity effects and then the MPS HPL. So that's all you need.
All right, so we'll just see if we have any questions for you before we hear from your witnesses.
Thank you.
Okay. Any questions, Ryan? Andrew, any questions on legal matters?
Yeah, look, just got one. Thank you for your legal submission. I mean, I've raised this before and for the previous submitters, and I've probably raised it at the transport hearing as well. It's just, I'm just still trying to get clear on how, I understand how the rezoning to the medium density residential zone is consistent with and I guess consequential or supportive of the Enabling Housing Supply Amendment Act. I'm still struggling to see the nexus or the link between how the changes proposed to the knowledge zone to create a living precinct relate to I guess supportive of or consequential on those the Enabling Housing Supply Amendment Act. Can you just join the dots for me a little bit, because it's not a relevant residential zone, so it's not MDRS are not relevant, and then then I guess what is it? Is it what's your link back through to that act? Can you just join the dots for me, please?
I think it is enabling of housing because it makes the activity status more enabling. So I think at the moment, or Jason would know better than I would in terms of activity status, but certainly under his rules, it will become restricted discretionary. So it certainly is more enabling of housing. So that's the basis on which I think that there is that connection.
Right, and is that okay? So that's so simply more enabling of housing basically is the argument as to how it's consequential on the medium density residential standards being applied to relevant residential zones and density changes in non-residential zones. And so for under policy 3, so if I'm clear that density is actually decreasing in the NOS zone though, is that right? Because the height limits are decreasing, is that correct?
Yes, there is a proposal to reduce it. So I think as lodged, we were suggesting 30 metres as a height limit.
Right.
But to address the concerns raised by Ms Wolfer, we have suggested that it be decreased to 11 metres.
Right. And so with the policy 3 test, it's height limits and density commensurate with the legal, what is it? Community services or community activities. So is that assessment being done at all? That for this different height?
Mr Jones can talk you through that.
Sure. Yeah, I'm just trying to get clear in my mind how that proposal relates through to the policy 3 and I guess the intention of that policy in relation to density and height and what that means for the NOS, which is adjacent to the town centre. Yeah, okay. All right, no further questions. Thank you.
Thank you.
Just, sorry, now I've got some questions for you. Just your paragraph 3.5. And you referred there to section 80E 1B Romans 2 and then policy 3, 4 and 5 of the NPS. And you say there this would include precincts. I was just wondering if you had any legal authority for that submission.
I haven't specifically looked for any, but I can find you some.
Yeah, just when I read those provisions, I don't see precincts being listed specifically. So I was wondering.
No, I don't think they're listed specifically, but I think that that provision is so broadly drafted that I think precincts are enabled.
All right, well, if you can provide any further legal authority on that, that would be helpful.
Yep.
No, that's the only thing I wanted to ask you about. The other matters have been covered through the conferencing, so thank you.
Thank you. Now, Mr Hickman's summary, I've got a hard copy here if you would like, or I can perhaps email that through, or you can have both if you would like.
If you printed off a hard copy, you may as well have them passed out.
Good morning. I'll just go through this. I'll go through the brief summary I've got prepared here. It's the research campus site presents a unique opportunity to redevelop a prominent brownfield site for residential and complementary uses. Currently, under the proposed district plan, the site is zoned knowledge zone. Such a zoning is not enabling a residential activity because that the zone permits residential only where it is for security purposes or living accommodation for its students or staff. We've engaged experts to undertake a range of assessments of the site to support the zoning request. Those assessments were in turn used to develop an outline development plan. That plan was attached to our submission and shows a mix of medium density residential zone and knowledge zone with a living precinct. I understand that the council officers are comfortable with the medium density residential zone component, subject to one outstanding issue associated with transport connections shown on the outline development plan. Mr. Jones has suggested some amendments to the knowledge zone provisions to address these matters raised by council officers. The living precinct is a key from our perspective because it's more enabling of a mix of residential and other use, which is what we expect to occur on part of the site. We have opposed the rezoning of the 19.8 hectares of the general rural zone land to MDRZ due to the reverse sensitivity effects on our research farm, which is located approximately 160 metres to the west. Similar submissions and opposition have been made by Plant and Food and PG Wrightsons. The rural research activities undertaken by Ag Research on the research farm are of a regional and national significance. If the land owned by the Stewart and others was rezoned, the use of the research farm would be significantly constrained for the reasons I described in my evidence. The Section 42A report recommends that the rezoning sought by the Stewart and others be declined, including on the grounds of reverse sensitivity effects. We support that recommendation.
Thank you, Mr. Hickmott. I'll see if we have questions for you, Ray. Andrew?
Thank you for that statement. Just one query, just in relation to livestock research. And I note from your statement that Ag Research has grazing livestock, and you talk about the consequences of the rezonings and the setback requirements for intensive primary production and buildings and structures accommodating cattle. It's just a query. So do your current activities involve livestock research, or is it more of a future issue? We currently undertake livestock research on our research farm. Yes. All right. No, thank you for clarifying that. No further questions.
So Mr. Hickmott, just interested, if we were to not find in favour of the living precinct for the residual NOS zone, would that affect Ag Research's aspirations for the rest of the site? I mean, are the two outcomes linked, or would the MRZ proposal go ahead regardless?
I'd have to consult with our experts around that. So.
Well, it's really you're representing Ag Research, who's the submitter and the landowner. So I think it's falls within your domain, with all due respect. So are the proposals linked or not? No, you're not allowed to ask the lawyer.
No, I know. We've come up with a plan that we think best reflects the best use of that land.
Yeah.
And I think what we're proposing here is our preference.
Yeah, I understand it's your preference, but my question was, if we were to find not in favour of the living precinct over the NOS area, would the MRZ part of your overall proposal proceed regardless?
Again, sorry, I don't mean to be flippant. I'd need to take advice because I'm not an expert on that, but I mean, yeah.
Okay. Well, if you can't answer it, you can't answer it. All right. No further questions from me. Thank you.
Thank you.
Thank you. So we've got Mr. Carr, Mr. Compton-Mon and Mr. Jones next. So I thought, given that there's some overlap, if you like, between the issues in terms of the ODP changes in particular, it might be useful to have all of the witnesses together. They can speak to the plan. We've got a presentation to show you.
Yep.
We've also got some hard copies of that if you'd like. But Heather does have that also.
All right, we'll just see. Does anyone, Roman or Andrew, do you want hard copies of the present? I don't need hard copies. Do you need? No, we're all good. We've got them online, so, oh, not online. We've been emailed the digital version, so that's good.
Good morning.
Morning.
Mr. Jones, I've presented to you virtually, but first
Yeah.
time in the flesh. So I think the way we're going to deal with this is work through a series of examples and graphics that Mr. Compton Barnes put together, just to speak to the remaining issues that are in contention, which I've summarized in the supplementary statement that I tabled last week. Before we get to that, can I just take you to Appendix 1 of my evidence in chief at page 8? So page 6, not page 8. There's a list of matters of discretion that start with the number 5 on the right-hand side of the
Just a minute,
table.
I'm still finding you, so. This is your Appendix 1 with all the knowledge zone provisions,
That's correct.
and you want to take us to
Page 6.
6. Rightio, yep,
Matters of discretion, number 5 on the right-hand side.
Yep.
There's a transcription error there. TCZ should be NOS. Okay. For the remaining matters in contention, the first matter that we want to speak to is linkage 1 as recommended by Ms. Wolfer. And then the second matter is the overall notations and associated narrative on the outline development plan for active transport more broadly. And then we also can take the opportunity just to comment back as well to the plan that Mr. Allen tabled earlier about the connection to the foodstuff site. So if we start with linkage 1, this is essentially an active transport extension to Kakahi Street that connects the street.
sorry, I'm just
Through
going
the
to
site.
interrupt again. What should we be looking at now?
Okay, well, you sure you don't want a copy? I'll give you a copy.
We've got it on memory still.
Sorry, I thought your presentation was going to be on our big
We
screen.
do have it. Yeah, yeah.
So if you refer to the
There you go.
4th page, which has a copy of the outline development
Yep,
plan as
good.
amended through the JWS.
Right,
And if you follow from Kakahi Street where that blue ring is.
Yep.
Over to the west. If you extend that primary road notation through a pedestrian linkage, that's what Ms. Wolfer's proposed.
right.
And
Oh, so that was her route 1, wasn't it?
Route 1.
Yeah, right.
Yes. I'll save the football puns for later. So the position that 3 of us have reached on that is that we don't think that's necessary. And that's stemming from a few different factors. Before we talk about those reasons, I just want to signal as well, and I'll refer you to another page that's in this document. Must be getting close. The concept plan, Dave. Okay. If you refer to, it's a page, revision D towards the back. That shows one of the scenario plans that was tested as part of the master plan process.
Yep, is that what revision D? is it?
Revision D down the bottom.
Yep.
Drawing number 2021-085.
Yep.
001. This is one of the concepts that we,
Page 21 out of 43. You're looking on the screen.
thanks. This is one of the concepts that we generated during the master planning exercise, and you can see there's a greenway notation that runs through the bottom. So the reason why I'm pointing that out is just to signal that this was something we expressly considered at master planning stage, and we ultimately discounted it for the reasons set out in our 3 respective briefs of evidence. So it was an alternative that was previously on the agenda, and we discounted it. We've since added notations on the ODP through conferencing that create a dog leg from the greenway, which we are providing to the east of that north-south primary road, to follow the primary road alignment to where it terminates with Crescent. And we feel like that's a strong enough signal as to active transport connectivity in that part of the site. The last thing I'll mention before I asked Mr. Carr to talk about Route 1 and its efficacy or otherwise from a transport point of view, is the intent of the associated narrative and the notation that we've used on the ODP from the outset. So we chose to use a different notation for those pedestrian and cycle linkages because they're off-road, they're dedicated pedestrian and cycle facility. And the associated paragraph in the narrative that corresponds with that is also dedicated to the off-road facilities. So there's discussion in the narrative of the ODP that talks about the primary road and how it too contains active transport connections. But there's also a standalone paragraph that's just about those off-road connections. And that also relates to the point of contention with us and the officers. So I'll just ask Mr. Carr to speak to the transport related issues with Route 1 and why we don't consider it necessary.
So I won't go through the introductions because I have appeared before you as well.
Yeah, no, you just go ahead. You good?
So the relevant section in my evidence is from paragraph 6.3 onwards with regard to that link. And that's on page
Sorry,
11.
what paragraph was that?
Paragraph 6.3,
0.3, yeah.
top of page 11.
Yep.
And essentially, the contention from a transportation perspective is relating to the convenience of alternatives and the extent to which that route would be used. So in terms of alternatives, there is an east-west link proposed further towards the south, and that provides for a movement to and from the west and the southwest. And that means that the Route 1 linkage as proposed would be attractive or the most convenient route for a very small number of people. So in the first instance, in my contention, it would not be particularly well used. The second thing is relating to the alternatives and the disbenefit, I suppose, of not providing it. And that relates to if people couldn't use a link in that location, where would they walk instead, or where would they move instead? And as I say, we do have that proposed link further towards the south. And in paragraph 6.10, what I've done is I've worked out a worst case scenario of someone who would have the maximum walking distance if that link, if Route 1 wasn't there, to the link which is proposed. And that would be an increase in the journey distance of about 260 meters, or about a 3-minute walk time. So by not having the link, it only introduces a maximum of a 3-minute additional walk time for very people. And in a nutshell, that's the transportation case for why Route 1 is not justified in my view.
All right, we'll just see if we have any questions on Route 1.
Just the one question I have is that this link at the bottom, the indicative pedestrian cycle route, so this one that's showing down through there.
Yes.
Thank you. Thank you for being able to see that from that distance. So where does it actually go to though when it hits, when it goes, I guess eastward, on the way towards Vernon Drive, to just Hooten it just stops because no one owns the land through there, do they? So there's not actually connection through, is there?
The adjacent development has a green link through that that section as well. So the idea is they match up.
Okay. Thank you for clarifying that.
sorry, just to clarify, you're talking the connection back to the east?
back through to Vernon Drive.
Yes, that's right. So the location of that greenway was proposed to line up with the existing one on that
Okay.
ODP area to the east.
Sure. Thank you for that. No further questions.
So this morning, we heard from foodstuffs who have agreed to if we find in favour of their proposal, a pedestrian cycling links into what would be their expanded car parking area, which is shown with, it was tabled with us this morning. Have you seen that?
Yes.
Yep.
Yeah.
So in terms of that additional pedestrian cycling link, have you factored that into your thoughts on Route 1? I mean, does that aid your argument against Route 1 or not?
That's a good question. It aids my argument against Route 1.
Yeah.
And what I presented to you and what is in my evidence was prepared prior to that particular issue arising. So the revised ODP, if that was to be accepted, does provide an alternative walking connection that wasn't taken into account. My evidence was on the basis of that being a worst case scenario. So it remains obviously a worst case scenario.
Yeah.
But obviously potentially even fewer people would be affected by that.
Right, thank you.
Thank you, Mr. Chair. If we could then move on to the quantum of notations and the associated narrative, it might be easiest to refer to the joint witness statement. We start with the Appendix A plan. So the understanding that I have from the joint witness conferencing is that the preference of officers is to extend the greenway notation along the entirety of the primary road alignment for consistency with the additions we've made to the northern greenway and the southern greenway. And we've set out reasons for why we don't support that in our evidence. I think to summarize from my perspective, the standard approach that's taken in other outline development plans in the district plan is that in all cases bar one I can think of in Darfield, the off-road notation is separate to the roading alignment. And as I say, I think only one example in Darfield do you see a parallel notation, and it's only for part of the internal primary road network. It would be an outlier for the entirety of the ODP to show a green notation alongside the entire road notation.
To be clear in my mind, is what you're saying is the officers, and I'll come back to the officers once we've heard from all of Ag Research's witnesses, but are they seeking green dotted lines to be running parallel to all of the black dotted lines?
Yes.
Right.
I'll just try to find the paragraph reference in the JWS. Paragraph 21. So the approach in the JWS that we've taken is that we agree that those off-road connections are important, both to Springs Road and to Development Area 6 to the east. And we also think it's important to indicate that those off-road connections need to be integrated with the on-road connections. And that's the changes that we've supported in the JWS. And I think it's important to also refer to the corresponding narratives I referred to before. So I'll just take you over the page to page 2 of Appendix A in the JWS. And there you can see the different color coding for the wording that's preferred by our team and the wording that's preferred by council officers. And so if you see under the if you like, the red bolded highlight subheading towards the middle of the page, our preferred version is the upper of the 2 options there. And this gets back to the point I made before, that the purpose of that paragraph from the outset has been to focus on the off-road connections. If I refer you back up 2 paragraphs, you'll see that the previously proposed paragraph there gets into the primary road network, which provides for good vehicle cycling and pedestrian circulation within the site. And then in the paragraph below, it makes clear that pedestrian and cycles access will be provided through to Vernon Drive as well and connect to Springs Road. So we feel like the blue text that the council prefers has already been represented as it relates to the primary road function for providing active transport connectivity. And the paragraph that's in dispute should focus on the off-road connections and their integration with the on-road facilities. The one remaining issue, if you set aside the duplication that I've identified with council's preferred wording, is the very last part of that clause, which refers to actively seeking to reduce traffic speeds and volumes to assist in achieving safe spaces. I don't think that from a design perspective, our team has an issue with that outcome, but expressing it in the plan, we do have an issue with, and I've set out reasons for that in my evidence in chief. Around paragraph 612, I believe. 611. From a transport point of view.
From a transportation perspective, I think the thing to highlight is that there is firstly the legal road width is always greater than the formed roadway that you see. And so there are no impediments if the road is formed to council standards, which we have every anticipation would be, why there would be any constraint on walking or cycling movements along that north-south route. And excuse me, and the second matter is in terms of cycling, the NZTA guide sets out a little graph which shows when on-road cycling is suitable compared to segregated lanes compared to a completely off-road cycleway. And the expected, or the likely traffic volume on that north-south road and the likely traffic speed means that cyclists sharing the road with motorized vehicles within a road that's designed for that and is providing a slow speed environment is the appropriate solution.
Do you want to ask any questions about that particular aspect?
Yep, let's do that, Roman. Andrew. So just going back to the ODP diagram. So just relating to what I've seen on the ground in Lincoln when I've been walking around the subdivisions out to the south of Lincoln that are all around those new wetland areas. So the little green dots on the ODP would be dedicated pedestrian cycling routes similar to what's in those existing new subdivisions, do you think?
Yeah, I've worked on the Te Whariki subdivision, if that's the one you're referring to. And yes, we would envisage those similar types of off-road facilities, but we'll be dealing with a much smaller scale overall.
Yeah.
And obviously not conjoining with extensive wetland complexes.
Yeah.
It's more about function here than it is about the amenity aspect.
Yeah, no, I wasn't referring to the wetlands, but just, I mean, that whole new subdivision is riddled with little pedestrian only paths that link between the roads, and we're just wanting to, that's what's contemplated here, similar kind of thing.
I say well equipped rather than riddled.
In terms of cyclists safely using the north-south link or the proposed new north-south road, so would there be like a cycle lane designated on that road, or would they just ride along the road itself?
It would need to be determined at subdivision stage, but because the road is vested, council has control over that process anyway.
Right.
But I would not expect that there will be a separate lane provided.
Yeah.
One of the issues relating to that particular road that will need to be grappled with is that it provides a really good little rat run if you want to avoid the Springs Road roundabout. So if you're coming from the south, you would potentially want to avoid the Springs Road roundabout, even when it's upgraded to traffic signals. You could scoot through that in that direction. So the north-south road would have to be designed really carefully to provide a very slow speed environment so that drivers were not encouraged to run through it. The advantage of a slow speed road is that it provides firstly greater amenity for residents, but it also then means that it's a safer environment for walking and cycling.
Yeah.
So it will be something that would fall out naturally from the overall design of the subdivision in due course. But no, I wouldn't expect that cyclists will be provided with anything specific. They'll simply cycle within the traffic lanes on a well-designed and slow-speed road.
Yeah. And then just, Ms. Jones, in terms of the different options for the wording and the narrative, when I read that, I thought, what's the issue here? Why is this a die in the ditch issue? And I'm still struggling to see what are the fundamental material differences between the two suites of wording, and what is the key areas of concern to ag research? And when I read them, just the blue words say in slightly longer form what your words say anyway. So I just thought, what's the problem?
I see there's two key differences. The
Yeah.
first one is that actively reduced speeds comment at the end. The other difference is that the paragraph we prefer is squarely about the off-road facilities and their integration with on-road facilities.
Right.
The council's preferred wording talks about the roading network as a whole, not just the off-road facilities, which we've already set out in paragraphs 2 and 3. So it's a matter of duplicating what we've already said. And I can show you from afar, you can see where I've annotated where all the duplications exist. I don't want to bore you with that, but I guess if you did take the time to go through, you could draw the lines as I have. For example, the references to Springs Road that pop out to you at the bottom of the 3rd paragraph and the beginning of the blue paragraph. Quality walking and cycling connections within the road corridor, which we've already set out in that 2nd paragraph. So it's purely a matter of duplication. I don't have a problem with the content from a planning point of view.
Right.
It's more the role and function of the ODP and the preference to avoid duplication.
And okay. And so the words, the blue, just sorry to belabor this because I find it fascinating. There's actually disagreement on this. So the words, the blue words at the start of their passage, active transport routes, is that what you're concerned about? Because that doesn't refer to off-road, it refers to active transport routes. But isn't is that the area of concern? Or?
No. It's the main area of concern is that our paragraph is purely focused on the off-road facilities, because we've already discussed the on-road facilities in the 2nd paragraph. The paragraph here talks about on-road and off-road, so we don't need to bring on-road back in. It's already been discussed.
So what's an active transport route?
It could be either a dedicated off-road route or an on-road route.
Right. Okay. And so Mr. Carr has explained how the north-south road will need to have what I call traffic calming measures in it to prevent rat running. So what's the problem with stating that in the ODP?
Well, for a start, you could be triggering by dedication consent obligation if you're reducing the carriageway width below the minimum. So you're imposing a mandatory consent requirement at this stage. If you're dealing with as an alternative, a lower posted speed limit, that's a political decision that's made outside the plan. So again, from an outcome point of view, I don't think there's any opposition to the roads being low speed.
Yeah.
It's just not stipulating them in the ODP for potential conflict that can create with those processes.
So if the ODP was to say that the primary north-south link should be designed to be a slow speed environment, full stop. But that doesn't specify how you achieve that, does it?
Doesn't.
And that would seem to align with Mr. Carr's expert view on what should happen on the ground. So that would be a suitable outcome.
I think that's suitable, provided that as I say, the overall mechanism to provide for that isn't one that's uncertain. And by uncertain, I mean relies upon a consent process to deliver, or a political process outside of the future subdivision and land use application process. Perhaps promoting slow speed would be a more benign way of approaching that.
Okay. Right. What's next?
I think maybe we'll just take a brief pause from the collegial approach and focus on the general knowledge zone versus the living precinct as a concept. And Mr. Hickman's commented on it. It's also referred to in my evidence in my summary. The key function of the living precinct is to unlock residential potential. At the moment, in order to achieve permitted activity status, it has to relate to students or staff or security. And if you don't relate to one of those uses, you're a fully discretionary activity and there's no policy guidance to support a decision maker to come to an outcome that that's an appropriate use. So that is the intent of the objective and policy that accompany the knowledge zone precinct provisions and the submission, and those remain unchanged in my appendix 1 to my evidence. I could respond to or provide a view to Commissioner Willis's question of Ms. Thomas before about density and the impact of the revised provisions that we've proposed as a function of policy 3 of the MPS. And my view is that we are reducing the height, which is a central focus of policy 3, as is density overall. So we're also seeking a reduced building setback, which means greater site utilization. And most importantly is we're seeking to enhance the permissibility of residential activities generally. So it's a coordinated built form and land use increase in development intensity that's realized through the provisions, not just a reduction in height. So that's why I support the precinct approach, because if, based on what we've proposed, residential activities proposed as part of a mixed use development, that could be permitted activity where located over ground floor, or if it's proposed at ground floor, it can be granted consent as restricted discretionary activity subject to design consideration. And that segues nicely into the provisions themselves and being able to ask Mr. Compton Nolan some questions about the provisions we've proposed, unless you want to talk about that concept of the precinct first.
So Andrew, do you have any questions on the precinct as a concept?
I understand the precinct as a concept. I think I understand clearly what the submitter is trying to achieve. Yeah, and I just had questions around, again, the relationship between the living precinct change and scope under the Enabling Housing Supply Amendment Act. And I think just referring back to your advice you provided us in the Transport hearing, where you told us or indicated to us that there were scope constraints around what we can or can't do, or the council can or can't do. And with reference to that, just interested in what your views are on these changes and how they relate to the MDRS or Policy 3 and how they fit within the scope of the Enabling Housing Supply Amendment Act in Section 80.
As a planner, referring to scope as opposed to a lawyer referring to scope, I'm mindful of the supplementary submissions Ms. Thomas gave you about the scope to include those consequential changes. In that example you're referring to, I believe, was the high trip generator rule. So I think any provisions that are in the residential zone, you're going to be dealing with those. As far as the non-residential zones, the scope, as I understand it, comes from the ability to change zones under 77N, provided that all the changes that you're making are consequential on providing for Policy 3 or the MDRS.
And are we providing for Policy 3 in the MDRS? Or are you providing for Policy 3 in the MDRS in your changes?
I would say we're providing for Policy 3, yes. The MDRS is clearly being provided for in the MRZ section. I don't think that's a matter of contention. I think as far as the NAS zone with the living precinct, I'd say that is consequential of Policy 3.
Building heights and densities.
Yes.
Right.
Or residential activities.
Right. So I don't see the word activity listed in Policy 3. It just for me, it seems to be about density.
I don't think there'd be an ability to change zones under 77N. If it wasn't the intent to provide for residential activity in those zones.
Okay. All right. Thank you.
Just want to ask you about 10-metre road setback.
Yes.
Is your proposal not going to include a 10-metre road setback?
That's correct. So the submission proposed to get rid of those to provide for greater site utilization and for more flexibility with the activities that you could realize in that land that's to remain in the knowledge zone.
Does that mean that buildings can be held up against the footpath?
Yes, just like the building we're in right now. And in fact, this is a good example of the outcome that you might see based on the bulk and location provisions we're now proposing, where you get a building of some length that has mandatory articulation. So what we're proposing now is that you'd have a building length that's comparable to this or the PGG building that's next door to the site, which you can see on our ODP, in overall length. But if it goes beyond 20 meters in one direction, you have to get articulation in the same way that you have with this building.
Are there any other buildings near it that are hard up against the street?
No, they're not. They're all set back due to the legacy of the knowledge zone provisions. I'll ask Mr. Compton-Nolan to talk about, just from an urban design point of view, why we think it's a better idea to have buildings able to get up to the corner.
The old tavern in Lincoln Town, I used to call it Bob's, I think I forgot the Rouse, or that's built up to the street frontage. The Westpac building, it's desirable for buildings to be built up to the street. We're trying to create a positive interaction between the street frontage and people in the building. It depends what activity is happening in that building. But we do find if you do build to the street frontage and you've got either a commercial or retail or office space on the ground floor, it provides greater flexibility too for that building to change use or activity or tenancy on the ground floor above. We've added a couple of photos into the appendix, just looking at the PGG rights in building. On page 14, I think it is. So on the PDF, I think it might be page 16.
Heather, you be able to flip those pages up on the screen?
Page 17, I think.
17.
That one round.
Yes. I'll back the other one, sorry. Get two more up, maybe. Next one. Yeah, that one. So the photo on the left shows the existing corner treatment. Got landscape planting, car parking, and the buildings obviously are set back quite some distance. And then the photo on the right, the aerial, shows the PGD rights and building. So your setback there varies between about 6 meters and 22 meters. And it has stormwater treatment basin and car parking. And that's what we find typically when you get to the design stage and you're required to have a setback, it gets utilised. And car parking is obviously one of the easiest things to put in the frontage because then you've got direct access off the street. It works really well from a car park point of view, but it doesn't work that well from a urban design or a pedestrian perspective. So that removing that setback restriction actually sort of encourages a better design outcome.
And we've provided some additional examples. If you want to look at those, they're on the pages that follow. These are just precedent images from Wellington and Canterbury and Auckland.
So again, this is sort of some of the other way, sorry.
No, the other way either.
Oh, you're right.
Maybe not. There we go.
Sort of pulled together a series of mixed use and multi-unit developments with a mix of setbacks and requirements. And this is a tendency in terms of they would sit within that 11 meter height limit that we're looking at, which would typically be three stories. You couldn't quite get 4 stories into that 11 meter requirement.
The example on the bottom right corner that you can see there is 50 meters from my house. It's 11 meters on the dot, and it has ground floor non-residential use. And above it has 2 stories of residential with mezzanines. So it's actually, it reads like a 4-story building. So that's a good mixed use example. The one on the top left, again, that shows how you can get modulation in built form through the setback. And one of the things that we've asked Mr. Carr to do with these examples is to illustrate the relative traffic volumes. Because one of the comments Ms. Wolfer makes in her evidence is about the amenity for residences based on the traffic volumes. And with the 4 examples you can see on the screen here, all of them have higher traffic volumes than our site, apart from the bottom right, which is in the neighborhood center in Wellington. And if we go to the next page, you'll have similar examples. Mr. Carr might want to just add to that.
Just one comment. That one on the top left is actually smack bang next to State Highway 1. So there's also Waka Kotahi involvement with that.
And so then on the next page, we've just got a series of Christchurch and Auckland developments that have been developed over the last 5 to 6 years. All have been really successful. A mix of terrace housing and apartments. Both the one on the bottom right-hand corner is on Manchester Street, So it's got a cafe on the corner, and then the rest of the development is residential. So it does have residential on the ground floor as well. And they've just addressed that through their fencing to provide privacy for that outdoor unit. But I imagine there's that flexibility that if they were to change to a commercial activity on that ground floor, like a hairdressers or another cafe, there would be that ability to do that.
So are all the buildings in urban areas?
Yes, they are. But
All the examples you've given are all in urban areas?
yes, they are. This is the way I see Lincoln heading as an urban area. Obviously, it has a character feeling down the eastern end. But this is how I see intensification happening in our bigger towns, actually. Yeah.
Would it be helpful at all to discuss the bulk and location provisions we proposed in this context? Are you reasonably clear on what we're proposing now?
I'll just check you. That would seem to be reasonably clear.
Okay. So I think that leaves probably the intersection upgrade rule.
Yep.
And the foodstuffs linkage. So Ms. Barker helpfully just commented on the intersection rule earlier. And I'll just make 2 comments on that if it would assist. The first one is I've anticipated potentially some comments about the use of the term occupation. And I've referred you at paragraph 3.7 to one alternative. Sorry, this is 3.7 my supplementary evidence. Where the point could be based on construction. Yeah. The reason why occupation was chosen is because any practicalities to one side, the effect as it's been identified by the transportation engineers is about the generation of traffic on the intersection. So it would be at the point of occupation that effect would commence. If a proxy is required, though, construction would be appropriate in my view. And I've also referred at paragraph 3.5 of my supplementary evidence and 3.6. The reason why I haven't also proposed a subdivision rule, which aligns with my evidence previously given to you on subdivision provisions and my interpretation of Schedule 3A.
Yeah, subdivision provisions are reasonably tricky, so they can be avoided. That's good. Should we see if we have questions on that rule? Any questions on the proposed rule relating to the 100 unit? Andrew? No, that's good. And thank you for that concession regarding occupation and construction, and it was in your evidence. And I do appreciate the staff's concern that occupation might be quite hard to measure and comply with, whereas construction is pretty straightforward, isn't it? They're built on that. Right.
So just if I could ask Mr. Carr briefly just to provide his view on the linkage to the foodstuff site generally, that he's comfortable with that, as proposed by Mr. Allen.
Yes, I'm comfortable with that.
Just so there's no ambiguity.
The close integration between the 2 sites has a transportation benefit in that it becomes far easier to walk to the shops. It also has a benefit for the supermarket in terms of reducing traffic generation, but it also then becomes an attractive area for people to want to move into because of that proximity.
Okay. So I'd just add one thing to that, if I can. I support the green ring notation that Mr. Allen's proposed on his diagram, but that's not been used elsewhere in our diagram. So for consistency, the panel may want to consider providing a similar notation where we're providing off-road facilities to the east to align with the development area 6 Greenway and to Springs Road in the northwest corner.
So should that be a red ring instead of a green ring? Is that what you're saying? Or?
No, the red ring is an indicative roading
Road.
connection, and that's to future-proof potential roading connecting through to present. So where Mr. Allen has proposed the green ring is at the eastern terminus of that pedestrian linkage. So I'd be suggesting that you, for consistency, might want to have one at the western end of that notation at Springs Road.
Oh, I see.
And if you refer down to the southern greenway, the connection to the Vernon Drive
Same
development
to me.
area. And the panel may also want to, for consistency again, consider adding reference to the supermarket connection in the narrative, consistent with the other comments about connectivity. And I think I haven't turned my mind to specific wording, but a logical place where that might be located, if the panel preferred our version of the final paragraph, would be the end of that red sentence you see, or somewhere in that red sentence.
Yeah.
For example, after the words outline development plan map, including to.
Okay.
I just wondered, given that Ms. Wolfer is here and Ms. Barker, it would be useful to know if they have any particular comments that they wanted to make on the refinements that Mr. Jones has made to the living precinct provisions and the not in the
I think I
north.
indicated earlier, once we've finished hearing from your witnesses, I'm going to ask 42 officers if they have any comments.
Thank you. Yes,
Yeah.
that would be good.
Yeah, no, I already said that. So anything else from the team?
I think that's all we wanted to address you on, unless there's any further questions.
Just check if we have any further, Rowan, any further questions from the research team, Andrew? No, no questions from me. So now to the 42A reporting team, you've sat through the hearing and heard what we've heard and heard the questions we've asked and the answers that have been received. Is there anything you'd like to add or amend in terms of your advice to us?
Yes, so I'll ask Ms. Wolfer to address Route 1 on the ODP, but just running through the other matters quickly. In terms of the ODP narrative, yes, the differences in the versions are very minor. And we did talk to the council's transport expert about the reference to a slow speed environment. And as that was a design outcome that we specifically wanted to achieve, that's why we included that wording in the narrative. But otherwise the versions are essentially the same. We also tried to use wording that was used elsewhere in ODP narratives in terms of the active transport routes. So that's the reason for that, rather than the strong off-road connection. Essentially, we're both trying to achieve the same thing. In terms of the foodstuffs connection, just picking up on those points that Jason's just raised. Yes, I do think there needs to be some refinements to the ODP just to make sure that those green circles are on all parts of the plan where they need to be. So that's something that we could put forward to the panel if you wish. In terms of the intersection upgrade rule, as I stated at the outset, that is something that we're working through and trying it to construction is appropriate in my view as well. So it's just getting the wording of that nailed down. And once again, that's something that I could put down in writing and circulate to the panel for consideration.
And that, so are you contemplating amendments to Mr. Jones's wording that extend beyond replacing the word occupied with construction?
Yes, potentially.
Like what?
So in terms of, well, I was looking to tie it more to what's the actual part of the construction process where that's actually going to be picked up by council, and that would be at the Code of Compliance certificate stage under the Building Act.
Okay. So just a more specific definition of what
yeah.
construction
Yes.
would mean.
Yes.
Okay,
Yeah.
right. And so you can provide some wording to us?
Yes.
Yeah.
And also still working through, I've heard that Ag Research don't believe a subdivision rule is necessary, but still working that through with the subdivision officer as well, just to ensure that there are no gaps if the site was to be subdivided. Potentially 100 households built, another part of the site subdivided 100 households, but how do we ensure that there's no gap in terms of, or alternatively another scenario could be that in excess of if it was the wording to us remain as occupied, more than 100 households could be built and not occupied, and then you have some issues there. So it's just trying to make sure we have no gaps in the rule framework. So I can work that through as well and provide a draft.
So just talk us through the concern with the need for a subdivision rule.
So if part of the site was to be subdivided, yes, you could have up to 100 households, and then you could potentially subdivide and have another, like a staged arrangement potentially.
Yeah, so what's the problem? What's the problem you're trying to resolve? What's the mischief that you're trying to avoid?
It's having more than 100. It's also how it relates to the land use rule, how we tie up site in that wording. So at the moment it's got within the development plan area. So yeah, it's just trying to avoid parts of the site being subdivided off and having an excess of 100 per allotment.
Still not understanding the concern, so try again.
So if the site was to be, the wider site was to be subdivided,
Yeah,
and 100 houses built
on part of the site.
on part of the site.
You're sure. That's all right. Yeah. Yeah.
And then another 100 houses built. So we're just trying to make sure there's not an excess of that 100 per site, and make sure it applies to the wider site.
That's what it says, doesn't it? It says within the development area.
Yeah.
That's why I'm not
It's
understanding the
just on something
concern.
I'm working through with the subdivision officer as well. So
Okay,
just
no,
to make sure.
right. I don't understand the concern, but that's all right.
I'll take that point on board, and I'll make sure that that's covered off in my response. The other question was around the NOS provisions. I considered those as part of the Section 42A report. There have been some changes in terms of building height, for example, which is supported by the joint witness conferencing. I haven't given specific consideration of those rules any further because I wasn't in support of the living precinct. So that's something I can do if the panel directs that. I'll just hand over to Garby, who's just going to talk to you about Route 1.
Heather, you able to put up that plan up that you sent?
Yeah.
What on earth is that
Yeah.
picture of?
Yeah, so I just wanted to provide a little bit of context and in regards to that route, what we've sort of talked about, Route 1, and just referring to that, we're creating a kind of a framework document with the ODP, so not really design into a detailed matter, but setting up kind of future proofing that site. And so in terms of Route 1, this has been sort of talked about not just recently and not just certainly part of this project, but part of the Lincoln University, where the master plan was developed to have all along a pedestrian link that links between destinations. And why I consider this Route 1 so important, because not only has it been referenced on that original master plan, it's actually the only link that connects between public spaces. So as in connecting Springs Road with Vernon Drive, and as in connecting the university with the extension of the town centre and the community services and facilities within that town centre. Whereas, for example, the connection that now has been enabled and which I'm supportive of at the top only connects into a private site, which is the Foodstuffs New World site, the supermarket. So while that's a great connection, it's actually providing just limited accessibility into that private site. Likewise, that connection that's been proposed to the south as a future connection into a comprehensive medium density site, again, a private site. And it's not, you know, it's also kind of really indicative where that's eventually linking up with the crescent. So this Route 1 is really the only central location, and once along Springs Road, there's also pedestrian crossing proposed that would align all up. That's really future-proofing this side to be connected with the destinations on the east and on the western side. And that's just what I wanted to reiterate and take the opportunity to do that. If there are any further questions.
Just with Route 1, just to confirm, I think we're talking about it will extend off that road that's got the little blue S under it. So you're just wanting a pedestrian and cycle extension or a road?
Yes,
extension?
yeah. So it's really an extension of Kakahi Street, and also there's proposal either side of Kakahi Street. So that's a public space, and that it's an extension to that. And while there is connectivity within the site proposed, people like to walk and take a direct route. So the most direct and legible road is the shortest connection. And again, it's an indicative where this is to be located. So it will be able to accommodate it in the future, you know, the exact point where this connection is, but it's sort of symbolizing and indicating that you want to have a Springs Road, Kakahi Street, Vernon Drive connection, rather than taking the route that's sort of proposed by the submitter going on that northern pedestrian cycle road. So I just feel quite strongly about that. There should be an additional route in the middle of this proposal, and I'm referring to the master plan and referring to the sort of plans around this site, as I said, with the crossing already talked about, and the further development that's happening south of Kakahi Street, which is proposed to be rezoned to town centre zone as well. So really strengthening that as a destination endpoint, and creating that link would be connecting to public space as opposed to a private site.
Yeah, that was a long answer to a question I didn't ask. So,
sorry.
So would the extension that you're asking for be a road or just a pedestrian and cycle?
Just a pedestrian cycle.
Just for clarification, so where Route 1 westward, is not currently a connection through though that subdivision, or is there?
No, so this is just again indicative. So that's at the moment the crescent development.
And I guess, yeah, okay, no, thank you.
So what's the distance on the ground between where Route 1 would terminate and what currently the picture I'm looking at is a house with a pink roof, between there and the green dotted line at the bottom of the ODP? So the dog leg one, what's the distance on the ground between those two?
So sorry, the dog leg, you mean like route 2? Yeah.
So you're saying to us, you think there needs to be a pedestrian site link going through there. How far is it from there to there?
I don't know on top of my head, I would say 200 meters. 200 meters?
Right, so it's not very far for someone to walk, is it?
No, it's not that far to walk. It's kind of more about the direct link and thinking more about the east-west.
picture that's up on the screen now, how relevant is that in light of the ag research proposal that's currently in front of us? Is that out of date now, or is it still current?
No, that's certainly in terms of what it's showing here, the individual buildings and stuff. Obviously, that's not what's proposed. But then I just want to say that we're looking at an ODP. I mean, the pictures that you've seen for the proposal for the ag research, they could change as well. They were kind of illustrations and, you know, concept plans. So I just really, you know, what I'm looking at is the framework, which is the ODP.
Right. So anything else from the 42A team?
No.
Well, good, thank you. So in terms of the your reworking of the intersection rule, what's your timing for that? How long? Did you say a day? Did you say by the end of the week? All right. It's just that the rubber's hitting the road now in terms of timing and the overall process, and we've got a lot to do. So, right. Any further questions for the officers? No. All right. Anything? I guess I'll give you opportunity to then reply. Anything you want to say before we wrap up?
It would be useful, I think, to understand, as my reading of Ms. Barker's report was that her concerns about the living precinct for the knowledge zone were based on Ms. Wolfer's urban design concerns. So it might be useful, I mean, if the panel's minded to understand whether the refinements in terms of things like, you know, the lower height limit, having seen the images and things today around the benefits of having those buildings on the road frontage versus setback, whether that's changed the officer's views.
All right. I guess that would assist us. So has anything you've heard today in terms of what would be proposed for the knowledge zone changed your views on the desirability or otherwise of the precinct proposal? I think there was a question from Ms. Wolfer, wasn't it?
It was.
So,
Yeah.
okay, so if I could just give Gabi a bit of context. So in terms of the precinct proposal, the key, I suppose, change was taking away the 10-metre setback from the road. So it's whether anything has changed today in that respect.
Yeah, so we heard from David Moen on you know, how you can actually place the commercial buildings on the road boundary and how that is positive, and I agree with his statements, definitely. The 10 meters was more as I guess in taking into account the 30-meter height. So having obviously a lower height is positive for the overall integration of this development. In terms of the setback, I guess that would have to be determined at design stage, because you still have on the ground floor residential at a busy intersection, and this is what I've referred to in my evidence, would be not a good outcome, just in terms of the orientation of the site being northwest, where most likely outdoor living space would be located. So I'm in answering the question, I'm supportive of the reducing the height to the 3 stories. Yes.
Yeah. And I'm still of the view that there's a discretionary activity pathway under the rules that present that could be utilised.
Yep, no, I understand that. Okay, thank you very much. If that's all, then
Mr. Jones might have one last point, if that's
we'll
okay.
be pushing that, but go ahead.
Sorry, sir, it's just that omission when I was doing my summary before.
Yep.
And it's just drawing your attention based on the conversation you were just having with Ms. Wolfer to paragraph 6.6 of my evidence.
Primary or supplementary?
Primary.
So,
and actually, I'll take you to 6.4 first. I think
just a minute.
Yep. Once you're ready. I acknowledge certainly, and in my conversation with my colleagues, I think they would agree. We understand the desirability for direct linkages.
Yep.
That's accepted. But then at 6.6, one of the things that I omitted to summarize before was part of the issue of concern with continuing that linkage through is to the outcome it has with potential redevelopment efficiencies on the Crescent site. And in particular, the awkward geometry of the cadastral boundary in that northeastern corner of the Crescent. It would help probably to look at the outline development plan you could perhaps just look at the one Mr. Allen tabled if it's to hand. You referred to the pink roofs
Yeah.
houses before. If you draw a logical connection of the Kakahi Street extension, we'll call it, right the way through to where it would join the north-south primary road, which we're showing as a future indicative connection, you end up with a bit of a dark corner there. And the logical development outcome could be challenging.
All right, thank you.
Thank you.
All right, so now we are scheduled to hear next from Mr. Barry Moore. So we'll just have a 5-minute break. We'll Egg research vacates and we might stretch our legs for a bit and Mr. Moore can move up. Good afternoon and welcome. You've appeared before at least, I think some or all of us before, so we understand.
Unfortunately, you have to put it with me again.
Yep,
Sorry.
So just proceed if you want to summarize your key points for us and then we'll see if we have questions.
First of all, I just want to start off with, I've just tabled this came late, so I wasn't able to present it. So this is additional evidence. You should have a copy in front of you.
Yep.
So in the report, it asked that I would need a soil contamination risk preliminary site investigation report. So you've got that there. So I'll start with that. So that we just run, if you don't mind, if I run through that first, just to familiarise myself with that.
Yeah.
You can see if you start on the map on page 6 there, this gives you basically an area of where it's done. You'll see that part RS 1064 on the bottom map there, 1702 and below are covered in this report. The other block has already been done prior to that, and it said in that report that they would need the whole lot done. The problem, as I said to you before, that I'm not the developer. I'm just proposing that wanting to get it subdivided so that someone else can do it, but I haven't got the resources to do it, and I was late getting this done, so I apologise for that. However, that shows you where it is. Does anyone understand where we're talking about, what the report covers?
Mm-hmm.
Okay, so the site description there on page 7, you'll note there that there's a description of the land, of the silt types and the soil types, and the nearby and the geology section there. Nearby bore logs indicate topsoils, underlying layers of clay, sandy gravels, and I'll speak to that later because that's quite important to revise to the high production soils, high production land later on. And one of the reasons why I want to speak to that. So the ground and it's just surface water. You're already aware that the Liffey stream and the L2 River runs along the western boundary. It actually should read the L2 River and alone. The Liffey stream joins it, so it's not quite correct there. If you turn over the page, you'll notice there that this property has been in my family since 1925. You'll see my grandfather, Harry Bradlaugh Moyer, took over the farm then, bought that then. And you might well ask, why do I now want it subdivided, seeing as we've been there 3 generations? My son was to take over, it would be 4. And you'd be right, 15 years ago. And really what's happened is that Lincoln's snapped up on me. And we've been surrounded by subdivisions and lifestyle blocks. So really, I'm left with no option really as to do what to do with the farm. So this is why we're doing it. You'll see there on 12th of February 1925, my grandfather and his wife, which doesn't say there, Sarah. In those days, you only put the man on the title. He took it over, and so we're shy of 3 years, been 100 years. So yes, there is an emotional attachment there, but I guess I'm trying to move with the times. You will notice there they've taken into account about what's happened all around us. You'll notice that they've got on page 9 there. One site within 100 metres, the subject site is the Lincoln Grange Orchard, which is might be a Hale area. Now that is, of course, the Liffey subdivision, so it's already been built on. And any problems they had there were overcome easily to form that subdivision. Over the page again, you'll see that there's lots of site inspection. When the lady came to do the site inspection, I explained to her the history of the farm, what has happened. It used to be a dairy farm all my life until 2000, when the council made me stop walking my cows across the road or along the road, so I had to downsize and sell. We switched to beef in that short time, and now it's being leased for sheep grazing. And so she made a note that there's no sheep dips or anything else in there. The northern portion, so that's the bit above Boyers Lane. That's the bit that's in the overlay, in the future growth overlay. She's noted there that there's no buildings there other than a hay shed in one corner. And that's consistent with what I've said in my further reports earlier on, that there's no hail areas need to be worried about there. You'll see one of the pictures there. There's water lying on the field, so it's on page 11, and that is sown at the moment in grass. We've had a very wet autumn, and they irrigated that block that Lisi did, and the surface water is just that, because I'll talk to that later on about the soils themselves and how they lend itself not to the high production land. The rest consists of, that you can go through later on, farm sheds and a variety of buildings. There's actually 3 houses on the property, 2 of which, all of them, built prior to the earthquake. 2 of them in 1955, and one in, just as I said, 1 year before the earthquake. So related to liquefaction, all withstood that. There was no sign of it at all. Other points they noted there, should we go through the thing, you'll notice that there's hail categories. There's obviously a bulk storage petrol tank. We don't, being a dairy farm, there's not a lot of chemicals used. Roundup being the only one, really, and not stored on property any more than what we need to use at any one time. So that's the detailed site investigation there. The maps on page, if you turn over, page is that, sorry, it's 19. So you turn over page 9, there was got some section of maps there from the land use register, and it's a good map there. You can see to the left, you'll see a good property map. There's to the left of that INV 303790. That is the proposed subdivision for plan change 69. And it gives you a good idea of how close they are. And above that there, you've got where the Liffey subdivision is. The bit in the middle here, you're going to get, I presume, Mamit Singh is going to talk to you later on about, they want that that covered in later on. So that butts onto the top corner there of that property. So that gives you it gives some quite good context there of what is going on around me. So they sum up, of course, that there's no, they identified nothing of major that would preclude any subdivision for hail reasons. So that's the basis of the report. So, and as I said, it didn't arrive till last week, unfortunately, due to a confusion of the people that were doing it, and unfortunately, I wasn't able to submit it. I will put it online. We'll email it to Heather so that you've got it as your records. So that was the basis of how I start on that. I do now want to respond to 1 or 2 points that came up in the section 42A report, just on a one-to-one basis. I'll find the right order. So the first one is to regard to the geotechnical, you've just got that, so that's covered. The other one is about the high producing lands. So a lot of people think it's a loss of high producing lands, and that is a concern. I agree, as being as a past farmer, of course, I agree that would be a concern. But I do contend that there's a difference between high producing land and versatile soils. So this property consists, and it says that in that report, of poorly drained soils that have a dominance of wetness. This is because the soil depth is mainly consisting of topsoil, but to about 25 average centimetre depth, with an underlying layer of clay. What that underlying layer of clay does, and it's the way we've had to practice our farming for all those years, and we had to contend with it, is that it traps the moisture above. So if we get a wet season, like we've got now, it keeps the moisture on top and it becomes waterlogged very, very quickly. And this makes it unsuitable land for crop, but makes it really good land for grazing, as long as you've got somewhere to remove the stock to in those wetter months. It's flaxed in deep silt over sand and over clay. And bore logs can indicate that there are underlying area of clay. They back up my evidence that I have been observing all year. I mean, it's one of these things you have to put. When they were building my house prior to the earthquake, they came to do the site. The site was wet, and they said, "Oh, we have to get a consultant in to do it, check it out." And I said, "No, you don't have to. It's because of the clay layer, and we've had a hydrant leaking, and the water's running over the surface. No, we still had to get a consultant out, spend thousands of dollars to get it, and the report said exactly what I just said. So this is what we've got. So that's the kind of soil it is. Okay, so it's very prone to compaction if you have too much stock on it. It's very, but it's also very hard to grow crops on. Once I gave up dairy, I tried cropping. Every single one of them was a failure. Two reasons. One reason, of course, was I'm not a cropping farmer, but the other reason was the soils didn't suit it. Our past practices of being a dairy farm meant that there was little or no cultivation of this land. And we had to use, to renew pastures, we utilised direct drilling. And as part of our farm environment plan, of course, that's what we have to do to minimise, and we want to do to minimise the damage to the soil structure. So I continue, these are not versatile soils as defined for the high production land, but of course, yes, they are fertile because of the wetness. We have to actively mitigate issues relating to that poor drained soil, and that is an ongoing thing. It's vulnerable to phosphate runoff because of that, because the water runs across the top of the clay layer, it takes the phosphate with it, and it goes to the lower places. And also to nitrate runoff as opposed to land, say around Rolleston here, where the nitrates and the phosphates leach down into the soil structure. Dairy farming, as we always did, holds the soil structure together. And this helps stop adverse environmental effects. Once you start cropping that land to any length of time, the soil structure breaks down, and you'll see the soil at a raining event, the soil gets carried away into the drains. I am the secretary of the L2 Drainage Committee for the Selwyn District Council. I've been on that committee for a long time, and I've just recently been sitting with Living Waters as a consultant to them to get this, to formulate a plan for the health of the L2 catchment, and cropping around this land would be detrimental, in my view, to the L2 catchment. I've previously seen there's a neighbouring farm who crops all the time, and every time it rains, the streams run brown with sediment. And as on our committee, we have to clean those drains far more often. So the definition of high production land, of course, is, I know it's a little bit subjective, but really it doesn't, we're not losing a lot of land, high production land here by putting this block into housing. Cropping here will be unsustainable. At the moment, I watch it every time it rains. I go down to the river and monitor it with the new leasee. He wants to crop it for 4 years, or some of it. And after that, as the soil structure breaks down, it will be unsustainable, in my view. It's crossed with, the property is crossed by drains that have to, if you're trying to farm it in the new regime of compliance, you have to fence it off from drains. You're losing land, and under the new Living Waters proposals, they want us to even fence off swales and everything else, cutting down the land. That makes it hard to farm it properly and feasibly. So as I said before, it's good for dairy as long as you've got somewhere to take your stock away. But of course, we're living now under a regime of changing goalposts and environmental costs and infrastructure costs. This makes it really hard to utilise this land as high production land. in the scale of things, there's 52 hectares there in total. There's 16 on the above block, above Moyers Lane, which is in the overlay, and the rest is below it. If you took in the catchment, there's 100,000 hectares of good medium soils, which are classed as high production land. Even if you took 52 hectares out, it's less than 1% that you're losing in the scheme of things. And if you look at it on a perspective, there's lots of land left, even if you do take this out. I'm not saying we should be taking land out, but when you're right next to a town, it's hard to farm it properly. So it'll be minimal. So less than 1% will be lost. I got those figures from the Carter Group Plan 69 change. That's what they used, and those figures were able to convince the obviously the commissioner there to make his decision in their favour. My soils are very similar to that. There's a map here. I think I'm giving the map out to everybody. This map here shows the soils. The Plan 69 one is in the red, and my one is beside it in the blue, just written down in blue. And you'll see the similarities of the soils. In their report, they had 1% of versatile soils of the land. They want 4%, sorry, 4% of the land, and the rest was similar to mine. So they came to that same conclusion. So really what we're saying is, what I'm saying is here, we can't have your cake and eat it too. You can either have high producing soils and put it into cropping, but at the risk of then losing the environment. We don't want to degrade the environment at all. So then the other option would be to sell the property if it doesn't get subdivided, allow subdividing. The same outcome would happen. You would still lose your high production soils because they would be retired. A farmer wouldn't buy it, and I don't think anyone in this room, to be fair, if you were in my position, would want to buy my farm and try and farm it right next to Lincoln. It's really, really hard. So it's more likely to be bought by a land banker and semi-retired. And you only have to go around Christchurch in any city, anywhere near the, and this is my experience over my lifetime, you see a block of land that's a farm beside any subdivision, it immediately downscales and it's lost to farming. You can just drive through Horswell, you can site anywhere. They bought by land bankers and they're not, and it's wasted anyway. So even if it was sold, and this happened to me on the block on north of the wetland, I sold that to, in the end it's been through 3 developers, I believe. All those years, it's just been sitting idle and hasn't been properly farmed at all. So the land's already lost. And I'm saying this would happen here in my property too if I was to sell it. It's not suitable for orchards. There was an orchard obviously above me in that plan that he struggled for years to make that work and it didn't. I'm a bit lower. The frosts are a little harder where I am from that orchard. And so it makes it really, really hard to manage an orchard. And you only have to look around. There is no orchards in the district really at all. The other options might be glass houses or maybe chickens or something like that. But again, I don't think anyone in their right mind would put out the infrastructure costs when this land is so close to Lincoln and there's a lot of uncertainty about what's going to happen. And of course, the old phrase, of course, reverse sensitivity is a really rears its head all the time. It makes it stressful, that sort of thing. And my conclusion really for that part is that the property is surrounded by urban and lifestyle blocks. The zoning of 1 house per 50 acres is really obsolete. With the plan change 69, it's going to open up the Moyers Lane. It's going to cut the top third of my farm off, and I know you've heard this before, but I still want to bring it up. It would suit, especially the above. It would suit the subdivision above the Moyers Lane, and as we've talked about before, maybe the bottom of the smaller lots. Now you could put smaller lots in there. You'll notice in that report that there is a tenant I've got that has a market garden there. Market gardeners really don't want big areas of land. They only want small areas of land so they can contain and work it on a basis where they don't have to pay a lot of money for wages and stuff. They manage that. He manages that on his own. And so having smaller blocks, people may, if you even, I'm talking about 10 acres or even smaller, may entice people to come and buy a land and then keep it in production. And having said that, I've had several people ask me, have I got a block of land I could sell them? So they could do just that. And as I said before, I've never had anybody knocking on my door saying, can I buy your farm to farm? And I do not believe that's realistic to expect. So, but deep market gardens might work, and that might work. As for transport, obviously the with plan change, if it still goes ahead, and they've got more armour to support them than I've got, backing them for lawyers and stuff. If it does go ahead, the first thing they have to do is open up Moyers Lane. The council will require probably my corners to help build that anyway. So they'll need to purchase the corners to upgrade the roadways. So for the block north of Moyers Lane, it would easily be integrated. It would not add much to the traffic problem because the traffic is already going to be coming through. Does that make sense? Yep. So they would come out that way. From an IPI perspective, I supported the IPI. I think basically it's a good idea because what I'm seeing now with the subdivisions in Lincoln is the more subdivisions go in, the more roofs we get, the more roadways go. And from a drainage perspective, and I'm putting on my drainage cap now, the water runs off really fast. And if you have houses that are higher and you get more people on the smaller amount of land, you've got more green areas to have, more parks and stuff, which is a watershed. And so, and you can also put in more ponds to trap the water from going in. The pond at the bottom of Liffey Springs waterway, they've got ponds in there. Every time it rains, they are immaculate, the water coming out of there to the visual eye. The water coming out of the Lincoln wetlands is a different story at the moment. It's when it rains, it's still clouding. And I go down there every time it rains to check on it because I'm worried about my property also adding to the mix. So yeah, so for transport point of view, I believe that that will not add anything to the transport. I would like to see basically in the long term, if it ever gets subdivided, that Collins Road East would be opened up. You've got a throughway then from to Little River, would go across there. You've got a bypass to Lincoln as well. And later on, as that block fills up, because I would say if you put it into 10-acre blocks or smaller blocks, it would be a buffer zone from Lincoln. That's what we need now, in my view, as being a victim of urban stealth. I believe there hasn't even been enough buffer zones around to keep that at bay, to keep a buffer zone, to keep the urban away. The case in point is the Lincoln University Ngaitahu subdivision that's now bounding Plan Change 69. When they originally put that through, they included a buffer zone of 10-acre blocks. You might remember, I don't know if you do. And as soon as they started to develop it, they applied for a plan change to remove that, and which is what they've done. And this is what my comment of stealth, how I'm a victim of being surrounded by stealth. And I firmly believe, much to my regret, because it's a family farm for 100 years, that eventually, if not happens this now, it will happen. This property will have to be included. Eventually, will be swallowed up by Lincoln. So that's just how I see it from now. That's really what I know. You've heard it before. The urban overlay, the block that's in the urban overlay. I do feel that if plan change 69 goes ahead, then that would be a no-brainer to include without any adverse effect to Lincoln. If you would stand on that block, look, you've got the wetland to the north, which is a park area. A lot of people like to walk in there with their dogs. It's got the cycleway going through below along Moyers Lane, and there's a lot of amenities there. That certainly is an attractive prospect for anybody wanting to live in that block. South of Moyers Lane, I mean, really, yes, I'd like to live there as long as I could, and as much as I could, but whether I'll be allowed to financially is a different story. So that's the basis of my submission, please. Thank you.
No, thank you. As you've indicated several times, we've heard from you before. I think it was in the Lincoln
Yes, we have.
rezoning hearings.
I get put on this one too, so
I understand that, but in that earlier hearing, we had a discussion about your aspirations for the land.
Yep.
And I think at that time, you indicated a desire or an outcome that would be satisfactory for you would be to have the plan provisions being amended such that you could subdivide down to 4 hectare
yes,
blocks.
that's right. But at the moment,
just a minute.
oh, sorry. Yeah.
So is that still an outcome that you'd be?
Yes,
happy
yes,
with?
yes. Yes, it is. The reason I was sorry for my interjection was that at the moment it's still zoned, and I've never seen any indication apart from your words that that would be in any plan. So it didn't certainly come up in any section 42A.
I understand that. I just wanted to confirm that
yes,
the discussion we had at the previous hearing is still valid from your perspective.
Oh yes, yes, it is. I mean, I'm just the whole reason I said to you last time as a plan is I'm trying to forward think.
Exactly. Yeah. You just want options.
And the reason I offered the that below Moyers Lane for I think a light industrial I put down there.
Yeah.
Because basically that's what it is already. Because of all those farm sheds. They're all obsolete farm sheds now because they and basically that's what they are.
Yeah.
If I was given permission by the council, I could lease those sheds out to light industrial, but I can't. They're just sitting vacant at the moment, for example.
Exactly.
And so it wouldn't change. What I was getting at then was it wouldn't change how the land looks.
Yeah.
If it was put like industrial.
Understand. See if we have any other questions for you, Raymond. Any questions?
So I just have one. I think you mentioned before about liquefaction because I saw a report.
Yes.
That there might be a peak base.
Yes, thank you for alerting me. I left that out. I must have skipped it over in my notes. Now you will notice in that section 42A, it said that we haven't got enough geotech information, and I agree. But we've got an indicative one there where we put the house. Built this house recently. Because it's not a subdivision, I'm not sitting here like the previous people. I don't know what they were. I didn't actually see what they were, but I have not got a subdivision plan in front of me. We do not know where to go for the geotechnical results. All right. Now, all those houses had been built prior to the earthquake, and none of them suffered damage from liquefaction at all. So again, for the proof is in the pudding, really. Now, the same thing applies to all the houses around me. All right, so the only liquefaction happened on the other side of, and Councillor Lyle's not here, but he knows what I'll be talking about if he was here, because he was here helping me shift the liquefaction from the same property. It was the other side of the Horsell River. So the liquefaction they pointed to was very deep, and it never came to the surface. And that remark that they made, and I agree that there isn't enough geotech. The reason there's not enough geotech, I have not got the funds available to carry out that as yet. But if there was a subdivision going ahead or in a plan, that would be definitely done. So the results came, of course, from the well drill. We had to drill a well, and the substructure was, as we pointed out, this much soil, clay, sandy loams, and then shingle at 7 meters down. I don't know where they found the liquefaction in their report. Now we did 2 actually. I can't find the other report, unfortunately, because we had to shift house, and it got lost somewhere in the packing.
I don't think the report said there was actually liquefaction. It just said there was liquefaction capability.
Capability, that's correct. Yes, yeah. And I'm just saying that we only had to replace one building after the earthquake, and that was a garage, a brick garage that was really constructed. The two houses, just incidentally, just to keep you informed, the two houses that are on the property, built in 1955, they are a ring foundation of concrete on piles, on blocks. And so after one house had no damage at all, the other house, the chimneys fell in because they made of brick, but the liquefaction didn't do any damage. The building that we had to replace, which was a garage, actually just jumped off the foundation altogether, which probably harks back to the building way it was built at the time. And in the photos there, if you get to look through that, you'll see there's a pile of bricks here as mentioned. The pile of bricks was from that garage, and we were going to build a weeping wall and a draining system. There's a drainage system there. I think on my original report, where you would put your ponds for your water retention, and I was just going to put that in as an added bonus to filter out any water that's coming off my sheds. It's still got to be done, but it's just got a bit wet. As opposed to above Moyers Lane, of course, there's a drain that goes between the wetland and me, the council, in their wisdom. When they built the wetland, ignored me altogether. They built another drain, so we've got two drains running along that boundary, the wetland and the fences in the middle. We can't get to the fence, and so that could all be taken out, and there'll be quite a substantial wetland there to add to take off the runoff for any future subdivision. There is another block there, and actually, probably if you see it in the photo, if the photos show up there, let's see if she took a photo or not. So if you look at the photos, so the 1974 aerial shows it. Perhaps that's the best one that shows up. So if you look at the 1974 aerial and this one here, you'll see above Moyers Lane, and Moyers Lane's in the middle there. Does everyone see where Moyers Lane is? Where the buildings, farm buildings are?
Yep.
You go immediately above that, you'll see there's a dark line in the middle there. That's the Maricarpa shoulder belt that's there. You come over diagonally down, and you'll see there's a bit of a mark there. I use that already as a silk trap. There's a silk trap already there, and if I was subdividing and I was planning that would be where I'd build the any ponds for a wetland reticulation, to keep the water from entering the river. So that's where it is. The far right hand corner of that map, you'll see there's a bit of a triangle there. That is probably that's not my property. That is a neighbouring property. He's south of the wetland there. He planted that, or the previous owner planted that in swamp gums, and because of the shallow soils of the swamp gums, they all blew over in the wind. So that's good to say that forestry is not an option in there either, really. We've tried to grow pine trees in there, and the wet soils also make it hard for them to flourish. So native bushes flourish, but the wetness, if you don't get it right, they will drown out. So yes, that's
Okay. Thank you. Rowan, anything else? No. Andrew, any questions?
No, you've heard from me enough.
Yeah, look, I don't have any further questions either for you, and thank you for coming in and expanding on the issues that you discussed at a previous hearing. So we do understand your concern, and we will giving it serious consideration.
Yeah, thank you.
Thank you.
All right, thank you for your time.
No, you're welcome. So we're now adjourned until 1:30.
Caught up a wee bit.
Yeah, thank you. Good afternoon. We'll reconvene hearing number 8. We were hearing submissions on rezoning in Lincoln under variation 1. And at this stage of the day, we're hearing from submitter Manmeet Singh. And just before I turn over to the submitter from the 42A reporting team, anything to add for us at this stage?
I would like to add that with Mr. Rossiter's evidence for transport, he's included a variety of cross sections of the road, which we would like the opportunity to have peer reviewed by our transport expert, please. Yes. Yep.
Right. Over to you. And I think you've appeared before us before, haven't you? But just in case anyone's watching who hasn't been part of a hearing before, thank you very much for providing your pre-circulated material, including the legal submissions, which we read. So you don't need to read out loud any of that material to us, but you yourself and witnesses are very welcome to highlight key points or present summaries, and then we'll see if we have questions.
Thank you, Sarah. And that was how I was going to begin today, by saying that you've already heard from me on a number of occasions through the proposed district plan seeking zoning up to general residential. And so now the submission seeks to convert that to the medium density zoning available through the variation. There has been something of a convergence of positions between the submitter and the council, with now general support for the rezoning sought, subject to resolving a couple of outstanding matters. So they are the odour setback, and the submitter's position there is that they would accept the 100 metre setback, and that a no complaints covenant is not required in terms of the effects anticipated on this site, but is still available to you if you considered that it was necessary. And then in terms of transport, as you've just heard, Mr. Rossiter has prepared a number of cross sections. We anticipate that final form of that access way would be determined during subdivision or engineering approval stage. Mr. Rossiter's evidence demonstrates there's a number of different ways in which appropriate access can be provided to the site. That was really all I wanted to highlight to you. Thank you.
All right, shall we see if we have any questions arising from the legal submissions, Raymond? No. Andrew?
No.
Just in terms of that last issue, and you raise it at your paragraph 11B. Which says the resolution of the Allendale Road cul-de-sac turning head and where it enters the proposed development area. I was just wondering whether or not, well, I'd put to you that should be reflected in the ODP narrative. I'm not sure if it is at the moment, that matter would be, that's a matter that needs to be resolved at time of subdivision.
Yes, I think that would be appropriate to reflect in the ODP narrative. I'm trying to recollect from various versions of that I've seen whether it has been, but I'm sure Mr. Thompson can confirm that with you. There is ODP narrative attached to his variation 1 evidence.
But you'd agree, and I think I had a quick look through and couldn't see it, but if it's not in there, then it should be.
Yes, I think that would be appropriate.
Okay. Let's see if I have anything else for you. Just the issue of the mid-site bridge, and Ms. Barker, just from you also. So the issue of the mid-site bridge, has that now been resolved? So mid-site bridge not required? Is that an agreed position?
That's my understanding. There's the ODP connection to a potential bridge, but the bridge isn't required in order to facilitate the rezoning.
That's my understanding too, but if we could hear from Mr. Thompson on that, because he's had discussions
Yeah.
with council's urban designer that I haven't been privy to, so I'd
Okay.
like to hear from Mr. Thompson on that. as well.
I think you would be better to hear from Mr. Thompson on that. I think he can elaborate further.
Okay, so Ms. Thompson, when we hear from you, I'm looking at your Appendix 1, the ODP map. And if you could just address this issue of the mid-site bridge, is that just to confirm where we're up to on that? And I've got some more questions for Mr. Thompson when he comes up, but in terms of legal submissions, nothing more from me. Thank you.
Thank you. So I'd anticipated to hear first from Ms. Neuenhausen.
Yep.
So I'm Kathy Neuenhausen, ODA expert, and I understand that you've also pre-read my evidence and rebuttal evidence provided to you.
Yes.
Excellent. Also have been here a few times before, but
Yes.
Just in summary, we've looked at the understood use of the Lincoln ponds. My assessment has been limited by the understanding of how the old wastewater treatment pond is being used currently, as it's not currently consented for any odor discharges. So consider the true emergency use, dilute wastewater in it as a flow buffering type situation, and there is other use that is not really clear or documented, which has made it more difficult to recommend an appropriate odor setback. But so I've considered it from what would be reasonable and based on my understanding of the pond use, and consider that it could be anything from 0 to the current 150 meters. But given my understanding of how someone use it, which is albeit limited, somewhere around the 100 meters would be a reasonable setback to allow Selwyn to manage the operation to meet a acceptable odor effect at that level, at that distance. Sorry.
All right, just see if we have questions. And it was interesting, you said you have appeared before us before. We were just during the break, we were trying to remember how many times we've had this particular issue in front of us at the various panels on the way through, not only in this,
Every time I have to ask, which
not
one
only
is.
in this variation one process, but in proceeding. And I think we're up to about the 5th or 6th time we've had this matter before. So, but anyway, any questions on odor?
Is health affected by breathing wastewater odor over a period of time?
For the type of pond we've got, we would for wastewater we consider pathogens, but typically that's from spray irrigation type situations when you've got droplet formation. For a pond where it's just sitting there, it wouldn't be my expectation that there'd be any direct health effects related from any compounds that come off the wastewater pond. And in terms of odor as a health effect, yes, people can have health effects as a result of being exposed to odor over a long period. Chronic odor effects can result in stress, which is probably the key health effect, rather than a direct physical health effect. Sorry, I'm not a health expert, but the exposure to odor in itself isn't a health effect, but the stress caused by that exposure can result in a health effect. Yes.
So more mental health effects.
That would be a good way to describe it.
Okay. Thank you.
Thanks, Mr. Chairman. Look, I just have one question. So I'm just interested on your views on, is the site likely to be utilised more going forward with all the, I guess, increased development in the area, or actually is it likely to still remain the same type of activity and frequency of use that it is now, despite that, noting its activity now and its purpose within the, I guess, the wider treatment system?
Yeah, so in terms of the activities I've looked at, I did consider that because there obviously is a lot of subdivision happening, or a lot of planned subdivision or hopeful subdivision. So the 3 types of uses, the flow buffering when you've got a storm event, obviously the more flow, the more frequent that would be, but the resilience planning report looked at that. So we looked at quite a relatively high population for that, or I looked at that. The true emergency use, you'd have to ask a wastewater engineer, but I don't think if a pump's designed appropriately, it's not going to break down more often because it's a bigger pump, I wouldn't have expected. So I would expect that use wouldn't change. If you've got a higher flow through it and it's designed appropriately, then that would be appropriate. In terms of the other uses, they appear to be all linked to maintenance and repair program,
Okay.
which again, I don't think would change as a result of an increased population if it was designed for that increased population. But that's, I did consider how it would change, and that's within my OD expertise, that's where it is. If you wanted a more precise answer on that, you'd need to talk to someone who understood wastewater system design better and whether that would be increased.
Sure. No,
Yes,
thank you for
yeah.
that. Thanks for the answer.
We did consider that.
Yeah. Thank you. No further questions.
Thank you.
Sorry, I didn't have my mic on. No further questions from me.
Thank you. So the next witness is Mr. Roster.
Afternoon. Just confirm my full names. Michael Christopher Roster.
Yep.
You have seen my evidence. Focus of my evidence was only to address the concern raised in the council's report and whether or not the narrow section of road represented a fundamental constraint to the rezoning. With that in mind, my evidence put together 3 potential road cross sections just to demonstrate that it should not be a fundamental constraint. There are different ways of managing the narrow section of road. I don't plan to go through the details here unless you'd like me to. I'm just happy to take questions.
All right, thank you for that. Raymond?
Thank you for the photos. They were really helpful. And I'm looking at one of them at the moment, and it's looking at up the cul-de-sac to the entranceway to what will become the site.
Yes.
That looks quite narrow. Do you think that will get used much?
At the moment, it's obviously the primary access for all the properties that are currently beyond the cul-de-sac. If the land is rezoned, the balance, it's going to be the primary access, I would think, for certainly new dwellings at the northern end of the rezoned land. Properties towards the south will potentially have more options depending upon how roads within the PC69 area are developed and which connections come with those.
So if all of the property in the locality does get approved to be developed, will that make the connections within the site more in use?
Yes, so that there will be more traffic on the existing bit of cul-de-sac.
You think 10 metres is wide enough?
It's wide enough to. The council's standard at the moment is to provide a carriageway with 7 metres. That's a wide carriageway for a residential road. I think it needs to be put into the context of probably the national subdivision standards, which published in 2010. The standard cross section in there is only a 5.5 to 5.7 metre carriageway. And then there's another group which goes from sort of 7.2 to 7.5. The key difference between those is what level of parking you want to allow for on the street. So at 5.5, you can have a person parked on the side of the street, and there is enough room for a truck, like an emergency vehicle, to go past. It's probably not as wide as Fens would like. Personally, I prefer roads on residential streets to be a little bit wider to allow for the bigger parking demands. But we do have to balance that with trying to keep vehicle speeds slow 3.5 metre lanes, which is the council standard, is a state highway minimum width. So it's a high speed sort of width for movement. So within 10 metres, you've got enough room to put in a carriageway that could be quite narrow for two-way movement and a footpath, or a wider footpath, and the balance then is where you put your services and how much separation there is between the footpath and the roads and the boundaries. So there's a bit of juggling, but there's plenty of scope to put in a two-way road.
And there'd be enough room for cycle lanes and.
You wouldn't need a cycle lane on this road. It's not, it is only going to be a local road.
Right.
You wouldn't normally expect to put a cycle lane on a local road.
Thank you. Thanks, no question.
Andrew?
Yeah, thank you, Mr. Chairman. Thank you for your evidence. Paragraph 15, I think you refer to greater control on vehicle speeds could be achieved with the introduction of a single lane restriction on the section of the road. So is that your preferred design option?
I think in this location, because of the natural restriction that we've got with a 10 metre, that having a sort of, if you like, almost a gated narrow entry to the larger subdivision to the south provides a natural speed control point, because you will always have to stop if someone's coming the other way. So I think it's a very sensible control, and would be more effective than just doing a narrower section of two-lane road with no parking restrictions.
Okay. And then, so bearing in mind what Mr. Thompson talks about in terms of numbers, 130 to 150 households utilising that single lane. In your experience, is that down elsewhere, or what issues does that create? Or are you telling us it's fine?
To my mind, I was thinking about this on the way up here, and if I think you should be aware, if you follow the state highway out to the west coast, there are a number of single lane bridges.
Yes.
Traffic volumes on there I didn't get an opportunity to check, but they will be substantially higher than the 800 per day that you would get on here if every single lot generated 8 movements over the day.
Sure.
Which, were 8 to 100 to 1,000 movements.
Okay.
With state highways for comparison, say they'll be up in there. For those sections, will be up at 2,000 plus.
Okay. No, useful answer. Thank you. No further questions.
Just following on from that discussion and looking at your figure 4, I mean, where I live in Napier, there's a number of single lane parts of roads that have been designed for the purpose of traffic slowing, but they have a preferential direction. So if you're going one way, you always have to give way to traffic coming the other way always. There's signs that require that. Would that be the case here, or would it just be open slather?
I think you have two options. Within a residential environment, I'm loath to start putting in signs unnecessarily. And with the lower volumes, it's usually not necessary to have it fully signposted. The sketch that I've sort of shown in figure 5, the intent was there to try and take advantage of the natural geometry, which meant if you were going north, for example, your movement, you've got to move to the other side of the road. And similarly, if you're coming south, you've got to make a right-hand turn before you go through. So you're having to do a bit of a wiggle. It's not just a straight through movement. So that's a very deliberate decision to try and say, look, if you do something like that, it really, you are forced to slow down much more. And there's enough visibility between there that I don't see the need for signs.
Okay. All right, and just in terms of your answer to my colleague, that figure 4, from what I understood, is the one that appeals to you the most as a traffic expert. Should the ODP specify that as the preferred outcome, unless at time of subdivision there's a good reason to do something different?
I don't know. At this stage, unless council wants to go as far as specifying the detail of that link, yes, I'd say it's my preferred option to go with a single lane. I think design, if the ODP just flagged that this is subject to approval or design approval with council, I'd be happy with that. To my mind, it's something that's easily resolvable through the engineering approval stage.
All right, thank you. No further question.
Thank you. Finally, Mr. Thompson.
Good afternoon. I have nothing really I want to add, sir, to what I've already written in my evidence. I'm just happy to go straight to questions. I've noted, Mr. Ross, that last question and the possible need to amend the narrative of the ODP. I don't think there's a need to amend the ODP itself, but certainly something in the narrative. Add that in. Look, it will be a very, I imagine it'll be one sentence. I could send that back to the team. I could probably do that as soon as. Yes. The Esplanade Reserve, the issue around that, my understanding, is whether or not there is public access, and if there is, what type of public access. One of the houses is quite close to the stream, and I would suspect that we won't get 20, or the council won't get 20 metres of Esplanade Reserve in there. As you'll probably be aware, that Section 229 of the Act sets out a number of purposes for Esplanade Reserves, including flood mitigation, conservation, recreation, public access. So there is a balance to be struck there, I think, as that what type of public access. It wouldn't be a cycle, I don't think, but certainly pedestrian access, conservation planting, riparian restoration, that kind of thing. That's what I would envisage coming out of that.
Do you know if the submitter has intentions to do that?
Well, it's by law. If it's subdivided, the council can require. The law requires 20 metres of Esplanade Reserve unless you get an exception made to go less. So there's no option. The issue will be how long it takes to get the full connection, because it really depends on how those properties are subdivided and the sequence in which it happens. So you'll get a gradual Esplanade Reserve building over time, depending on the rate of subdivision. If that makes sense.
Yeah, no, it does.
Yeah.
Thank you.
Yeah.
Thanks.
Thanks, Mr. Chairman. Just one question, Mr. Thompson. Paragraph 58, you refer to the site bridge across the Life stream and practical difficulties. What are those practical difficulties that are of interest?
Of getting the bridge over?
Yeah.
Well, well, I don't know. It should be reasonably straightforward. It'll be financial. I think that's probably what I was getting at there. Is how it's funded. And look, as far as I'm aware, it's not on the capital program of the council, so it would need to be on the capital program and then funded through either a local development contribution or an area-wide contribution, or if the council is really lucky, through Wakakatahi Cycleway Fund. That'll be the options. I'll just go to that paragraph and make sure that's I'm answering your question. But that was paragraph, sorry?
I think it was 58.
58, yeah. Oh, that's the mid-site, sorry, I
Yes.
beg your pardon, the mid-site bridge.
Yes.
Um,
Because there is one, I mean, the ODP shows a link further to the south.
Yes.
Yes.
yeah, well, the same practical difficulties apply here in terms of funding, but the mid-site bridge, you would need to acquire the land off private property owners and create that link from presumably what would be a cul-de-sac or a subdivisional road of some sort to get across the stream. So there would be practical difficulties in getting the cooperation of future landowners to do that.
Right.
Yeah.
Okay. No, thank you for that. No further questions.
Mr. Thompson, just following up on that. So my question to Ms. Barker, so there's no agreement that there's no need for the mid-site bridge. Is that your understanding?
Yes, Mr. Nicholson, and this was a verbal meeting I had with him, indicated that the bridge, he appreciated the practical difficulties in providing that footbridge and was satisfied with the single bridge at the across where it's shown on the ODP.
Okay. And just looking at your proposed rule, MRZREQ 12, and the rule that you've indicated or you've asked us to consider there requiring consent for residential activities within the ODA setback. What sort of activities did you have in mind?
So the residential zone here includes activities which are a lesser sensitive nature than residential. So for example, a minor residential unit, which doesn't require subdivision, that could well be for a temporary family member to stay in, or a granny flat, or that sort of thing. So that I wouldn't expect to be as sensitive to odour as a permanent residential dwelling. I mean, that's making an assumption that the minor dwelling, of course, isn't permanently occupied in long term.
Yeah, I don't know if my granny would agree with that.
Yes, I appreciate it. There is provision for visitor accommodation up to a certain limit. So there are activities in the residential, which are residential in nature, which I wouldn't anticipate having the same sensitivity to any potential odour effects.
Yeah. And if we're not minded to agree to your new rule, would those activities require a discretionary activity consent, or would they be non-compliant?
Well, they're permitted at the moment. That they would be I've got, I think a restricted discretionary would be appropriate, given that there is an odour setback, and enable the officers to at least assess, first of all, the activity, such as a minor unit, and assess whether or not there are any other mitigation matters needed.
Okay. So I'll ask a different question. If the ODP was to specify no residential activity within the ODA setback, in the absence of this rule that you're suggesting to us, would residential activity within that ODA setback require discretionary or non-compliant consent, or how would it work? Because it would be contrary to the ODP.
Well, the recommendation, yes, although I note the recommendation by Ms. Barker makes it restricted discretionary to put in 100 outside 150 in that case.
I guess I'll ask a different question.
Yeah.
In general terms, if an activity is contrary to what's in an ODP, what consent category does that default to?
I think that's restricted.
I think it's discretionary.
Discretionary.
Do you know, Justine, or Vicky, is it
discretionary?
All discretionary. Yeah, that's my understanding from previous hearings. So if we're not minded to go along with your rule, then residential activity within the ODA setback would require discretionary consent. So we could just be assessed on its merits. What's the problem with that?
Well, it's a discretionary activity is
pretty good from a decision maker's point of view, isn't it?
Yeah, it is from it's just really the cost, I suppose, for the applicant and that kind of thing for what would be a reasonably minor sort of activity. Other than that, there wouldn't be a problem. It's just transaction costs associated with it.
Yeah. Do you think a minor residential unit or visitor accommodation is a minor activity?
Well, they're permitted in a residential zone. Therefore, they're not anticipated to have any significant effects on residential environment.
Yeah. But in this case, we have an odor setback.
We have an odor setback, I accept that.
So it's not a typical residential environment. Is
No, that's fair enough, I understand that.
Okay.
It was put in, sir, really, because there are large lots which are going to be left over.
Yeah.
And there was a way of making perhaps a more efficient use of those sites than it would otherwise be, but they could equally stay as large lots, be attractively landscaped and serve, you know, a normal large lot purpose.
Yeah.
Yeah.
Or equally, a property owner could make an application under a full discretionary activity rule,
So-
present a good case, and be non-notified if they've done their homework
Yes.
and have a good outcome for them. I mean, that's possible too, isn't it?
Yes.
Right. So now I notice the ODP doesn't have a specification in it of any a household per hectare limit. I don't think, unless I'm missing it. I just want to confirm, so it's the applicant's desire for 12 households per hectare, or are you happy with 15?
That's been the ongoing issue. The concept plan which was submitted had two options, I think, 15, there was a 15 and a 12.
Yeah.
The 15 looked very crowded, to be honest. 12 was where you got about 130 from.
Yeah.
So I think from a planning perspective, I think 12 is the preferred option.
Yep.
Because of the, otherwise in this area, really squeezing 15 households per hectare. And also there are traffic implications of that, I think.
Yeah. So 12 households per hectare in terms of your planning view is appropriate because of the constraints of the odor setback and the stormwater management area?
Yes. Actually, I thought I actually put that in there, but.
Oh, you may well have done it.
No, I can't see it either now, but that can.
Oh, no, it's not in the ODP. I just.
In the narrative.
Yeah.
I could put that in as well, sir, if it's.
Yeah, there's standard wording that other ODP narratives have. There's a standard sentence they use where they refer to a household per hectare limit. So we need to have that there as well.
Yeah.
Righty. No, look, that's all I had.
Thank you, sir.
Thank you. Oh, no, that's not all I had actually. Going back to the ODP narrative. So I just noticed under the land use heading still refers to a 50-metre odor setback. So that would,
Yeah, that can be, yes.
Yes, that would
So
need
that
to
can be
change.
changed as
Yeah,
well,
yeah.
if that's.
Yeah.
Yeah, okay.
and then under the access and transport, see the third paragraph down where you've got some red words crossed out.
Yes.
And then, but the words that aren't crossed out says the ODP shows an alternative secondary road. My question is, where is that alternative secondary road on the ODP map?
Yeah, sorry. You got it. Oh, there it is. Yeah. That is the, yeah, so that's the one that's the one that goes in the internal road around it. Sorry, what I had in mind there was that if Allendale, for whatever reason, Allendale Lane, the council wanted to perhaps make that a cycleway or something, or a pedestrian route through there, then that provides an alternative route. But it is part of the subdivision plan anyway. It's not really an alternative.
So going back to my question, where on the ODP map is the secondary road that's referred to in the narrative?
Yeah. Yeah, it's not, I need the legend is, look at the legend.
The legend just has indicative local road.
Yes, it does. So they're actually local roads that would need to be fixed up.
Well, so you haven't answered my question yet. So
Yes,
where in the
it's not
figure-
on there. It's not on there.
Okay, so is the narrative wrong or is the map wrong?
I think the narrative's wrong. I
Wrong
need to
too,
check
yeah.
with Mr. Roster on that.
So the narrative could just omit that word,
Yeah.
omit that wording.
Yeah.
Because there is no alternative secondary road.
No.
Right. I'm just looking at the ODP wording under open space, recreational and community facility.
Yeah.
So the ODP is like a suite of consent conditions that apply to the developer. So how appropriate is it to have the words in red that relate to something the council may or may not do? Is that normal for an ODP?
It signals a possibility that that may happen. That followed discussions with the council's parks officers around whether or not they'd be interested in acquiring land here in the future. It's not on their capital program at the moment, but they may consider it in the future as a possibility.
So shouldn't the wording though put an onus on the developer to do something? I mean, I'm thinking of these as being akin to consent conditions. So shouldn't the wording relate to the landowner or the subdivider offering a larger green area rather than having an obligation on the council to do something?
I think it depends on whether the council wants to take this as cash contribution or land. In this case, the option it's basically saying, well, there is an option there for a land contribution in lieu of cash.
Yeah, right. Can you, together with council, think about some wording that meets my concern, which is that the ODP should make the developer do something, not rely on the council necessarily doing something, unless I totally misunderstood what these ODPs are for. That was the only other thing that I wanted to ask about. So you're going to come back to us with some revisions. Yeah. What's your timing on that?
They're not too, they're not too difficult. I'll try and get it by the end of the week.
Yeah, that'd be great.
Yeah.
Now, Ms. Barker, you wanted to, were you asking permission from us to have Mr. Rossiter's cul-de-sac treatments peer reviewed? What would be the purpose of that?
I just wanted our transport expert, Mr. Collins, to have a look at, in particular, those cross sections and make sure he agrees. And I can relay also to him what Mr. Rossiter said today in terms of his preference for the single lane and just get his feedback on that. I thought that may assist the panel with your decision making.
So would you be asking Mr. Collins if the cross sections are viable, or I'm just not quite understanding what the peer review model is?
Yes, in his opinion, are they viable in this context,
Can they
in
fit
this
in the 10 metre
location?
zone?
Yes, yeah.
Right. Okay. Well, it shouldn't take very long, should it?
No, so I was hoping I could get something from him by the end of the week and that could inform your decision making.
Yeah, okay. All right, well, we'll await that further information as well. And then, of course, that'll be copied to the submitter for their information. And we'll put that in the mix. All right, so I don't think there's anything else, Mr. Thompson, that we wanted to ask you. Just double check, Roman, anything else? Andrew?
No. Thank you, sir.
Anything else from your end?
No, just sort of thinking that through in terms of process. Ideally, we'd flush out issues about the cross sections at the hearing. So if the peer review hasn't been completed yet, I'm not anticipating that it'll generate any issues, but I guess reserve my position if it does come back and generate any issues. Obviously, Mr. Rossiter hasn't had an opportunity to talk to that despite being here today. So yeah, just really to flag that.
I'd be surprised too if it elicits any issues, since it's really just a spatial thing. Can you fit those cross sections into a 10-metre wide area, which seems to me self-evident, but
yeah,
we'll see what comes out. But yeah, if these issues arise, then of course you can come back to us on that. Just be aware of timing though. We're fast coming up against our deadline to get all of this finished. Yeah.
Thank you. Nothing further.
All right. Okay, thank you. So now, and look, our next submitter wasn't scheduled until 2:45. Lincoln Voice, Lynn Townsend. Is anyone here who's scheduled to appear this afternoon? Who are you? Okay. Are you happy to go now, or would you rather wait till 2:45? Excellent. So we'll just let these submitters vacate, and then we can hear from you, Mr. Townsend. just give us a minute to get the right documents in front of us. Right, good afternoon and welcome, Mr. Townsend. Thanks for agreeing to come up a little bit early. Now, we've received your statement of 7th of June, which you kindly pre-circulated. Oh, sorry.
Sorry.
It's all right. It's fine. So I'll start again. Thank you for pre-circulating your statement of 7th June, which we've had now the opportunity to read. So you do not need to read that out loud to us, but you're of course very welcome to either summarise it for us or highlight any key points that you'd like to make, and then we'll see if we have questions for you. Does that sound all right?
Yeah. I'm sorry. It's not my profession and this sort of thing, and in terms of summarising it, other than well, I think it's, you know, well, I've set it out fairly well as to the best of our ability. So I'm happy to try and answer any questions, but
thank you. And I see you have a colleague with you.
I'm Malcolm Stewart. Yes.
Right. Okay. And is there anything before we go to questions that you'd like to add at this stage?
No, I'm happy with answering your questions. I've read through all the paperwork.
Okay, that's great. Well, that's very efficient. So Raymond, any questions?
Thank you.
Andrew.
And likewise, I'm familiar with this proposal.
And Ms. Townsend, having read your statement, it very much aligns with, I think, information that's come forward from your group at previous hearings, where we've had a lot of information before us, including from experts that you and your collective have engaged, and legal submissions, etc. So I don't have any further questions for you arising out of the statement that you pre-circulated, but that doesn't mean that we haven't read it and take it into consideration. It just means it's clear on its face, so we don't need to clarify anything.
Fair enough. I mean, it's your understanding of what we've said. Well, then that's the matter's in your hands.
Exactly. So yeah, thank you very much for that.
Okay.
Thank you. Now, is anyone else here who's scheduled to appear after afternoon tea? Yes. Hello, who are you?
I'm Jill Gordon.
Yes. Are you happy to go now, or would you rather wait? Okay. So just that's cool. Can I use your glass? Your glass or something. Now, just forgive me for this question, but this is new material that we wouldn't have seen before.
No, this is additional material. This is some maps showing their location.
Yep.
And some photographs of site.
Okay.
And a list of our concerns that we have regarding the ODPs.
Okay, so you're just happy to walk us through this material?
Absolutely.
All right, over to you.
First of all, I do appreciate that you've taken the time in consideration of our original submission too. I just wanted to thank you for that as well.
Yep.
Thank you. So today I just brought to some additional information, really keen on showing the panel just exactly where our location is in regards to the ODPs that the submitters have put forward, and also some photographs from our site, and just listing some of our concerns that we have. I thought perhaps showing you our location might give you a better understanding of those concerns. As you are aware, there's not only the ODP with the industrial and the medium density, there's now also the option 2 as well. So because there's some overlap and codependency between all of those ODPs, I just thought we would bring all of those issues and concerns so that we will, because they are overlapping. So if I could just take you through that, those ODPs, that's the medium density, and you can see quite clearly, I've marked on here that Gordon and Thomas 1137 Springs Road, and there's a large triangle in the bottom of the medium density with roading, cycleway and stormwater paths going through there. And the industrial, again, we've got roading, stormwater, we're right there in the middle. And with the option 2, which is the third one, you can see there on 3 sides, we're surrounded by the proposed industrial.
Yep.
Just as way of background to how we found ourselves in this position of our neighbours rezoning our land, we originally had a meeting with our neighbours in December 2020, and we met with Ms Aston, and our neighbours were wanting to put a submission through to the proposed district plan. We didn't want to carry on with that because we have no intentions of subdividing. We are farming the land. And so we said to them, look, this is our position. If we ever wanted to subdivide, we'd be looking at residential, probably large lot, because it's in keeping with our current land use. And we felt that we had made our position fairly clear to the neighbours. We did read the 2020 submission, and we noticed that there were several proposals, different options, and given we'd made our position clear, we felt that we were comfortable our position was known by the submitters, and we didn't take that any further. Also, because of our inexperience with the district plan processes, the wording of their submission led us to believe that Selwyn District Council planners would make a decision on which option they wish to go with, based on strategies and plans that were already in place. So for that reason, we didn't submit any opposing view, more because of inexperience. And I guess too, we trusted our positions, our neighbours to honour our position. Yeah. When we found those plans on the Selwyn District Council site, we asked the neighbours to remove our land from the proposals, and we have an email trail to that effect. The issues I'd like to raise with you today, there's 7 different areas that we have some concerns around. And I guess the first one that we'd like to talk through is the landscape evidence put forward by Mr. Head in February 2023, and also the height setbacks that we've got a concern with. Mr. Head was engaged to give a visual assessment of the option 2 ODP, and how development could be appropriately managed at the site boundaries. In his summary point 14, he noted there were open rural pasture to the north. What he failed to note was that that's actually the full length of Tankwards Road is the PGG Rights and Kimahia Research Farm, and there are reverse sensitivity issues there that haven't been addressed. Mr. Head also noticed that changing the land use from rural to general industrial triggers changes in loss of landscape character, attributes and values. And his assessment concludes that these effects will be acceptable over time as proposed planting establishes and matures. As I said here, the problem for us is this: there are no proposals for us on the boundaries. So therefore, the visual effects and loss of amenity values for us will be unacceptable and ongoing. I have actually attached some photographs here of the boundary plantings, and you can see there on boundary 6, which is marked on the ODP. Boundary 6 is mature crowned poplar trees, which offer absolutely no visual or acoustic screening whatsoever. Very sparse planting on boundary number 5. Boundary number 4, there is no planting on a lot of it, and then we've also got dead and dying in decline poplar trees on the boundary as well. So there is no mitigation in terms of the landscaping. Mr. Head also lists the audience which will view any development in this area. He does not include either ourselves or the property owners on the corner of Springs and Tankwards Road. They are also have been left out. That's boundary number 7. Contrary to his evidence, our boundary, our property at 1137 Springs Road are external boundaries and not internal boundaries. And these need to have landscape buffer zones to mitigate any zoning. I've also noted here the intention to use our property and plantings to mitigate a neighbour's rezoning is unacceptable. The submitters have identified the ODP as a significant buffer area on the Barton Fields eastern boundary. And this was to provide noise attenuation from the industrial activities, visual amenity, and they've also placed a building height restriction on that eastern boundary as well. And we would request that this courtesy is extended to us as well. I'd also like to point out that option 2, which is this area where we are surrounded on 3 sides from the industrial, is actually contrary to and not in keeping with both the operative and proposed district plans. The operative plan states in policy B4.3.3 that's necessary to avoid zoning patterns that leave land zoned rural surrounded on 3 or more boundaries with land zoned living or business. And it gives the explanation and reasons for this within the policy. Also, under the proposed district plan, the general industrial zone objectives require that the amenity values of residential and rural areas adjoining the general industrial zone are maintained. No attempt has been made by the submitters to mitigate our loss of landscape character and amenity values. Should this rezoning proceed, we would request the following conditions of consent: a 3-metre high earth bunding on all 3 of our shared boundaries, with acoustic fencing on top of the bund and landscape planting on our side of the bund and fence, according with the policy and objectives of the proposed district plan to maintain and protect the character and amenity of our property. Also, in keeping with the eastern boundary, we'd like to request an 8-metre building height setback to all of the shared boundaries as well, should this proceed. In terms of the noise peer review, which was requested by the panel after the last hearing, it was noted as well by the acoustic engineers that there was no noise mitigation for our dwelling. It was specific about our dwelling at 1137 Springs Road. So that also gives weight to the need for the earth bunding and the acoustic fencing. Moving on to stormwater and the evidence from Mr. Hall. All of the ODPs show the stormwater flow path dropping to ground at our southern boundary and restarting on the other side of our property on the north. This is not acceptable, particularly as Mr. Hall states in his infrastructure report that there are deep layers of silt that are not conducive to soakage. And also in the soils evidence submitted on September 2022, the author also noted that wetness is an issue. Over 53% of the soils have been perfectly drained. Based on this, it's therefore highly probable that dropping the stormwater ground at our boundary will adversely affect our land drainage. All of the ODP plans show stormwater management and secondary flow under transmission lines on our land. As we're not accommodating any development on our land, the stormwater flow path will need to be shown on our neighbour's land. The use of our land to place the submitter's infrastructure on is not acceptable. The submitters will need to use their land for their development. Using our land for their financial advantage is not acceptable to us. So we would request that before any ODP is consented, the ODP is altered to show all infrastructure on the submitter's land. In terms of earthworks and clearing, of concern to us is the commentary in the Davey Lovell-Smith infrastructure report that the natural lie of the land will need to be fully transformed to form stormwater basins and provide for the secondary flow paths. The 3 of our property boundaries are adjoining. Altering the natural lay of the land has potential to adversely affect our land and our farming use. We've seen no plans regarding the topography and drainage. In regards to water supply, we have currently a legal right of easement to a shared household and irrigation well on the Stewart's block, which has consent to irrigate 20 hectares. It's been the customary use for the 4 properties, and we have been using this water resource for nearly 2 decades. All 4 landowners share the cost for the permits with the monitoring, the costs of using and maintaining the well and the infrastructure. And we require a continuous water supply for irrigation of crops and stock, which is our livelihood. So we would ask for a formalised consent condition that should an ODP be approved, our water supply will not be reduced to a metered town supply, which is unsustainable for us to continue to farm our property. Now, as regards Springs and Tancred's Road, we did note that in the flow transportation specialist peer review, which was requested by the board, there was a note there to say that, I think it was in paragraph 2.2, that the land that may be required for a roundabout is within the submitter's control and can be achieved. This is actually incorrect. The owners of the intersection corners are not party to the rezoning proposals. And further to this, 3 of the owners have contacted us and asked for the hearings panel to be made aware that they will not willingly make any land available for traffic mitigation. These owners have stated that had the proposals in front of the panel been fully disclosed on the map, the submissions mapping tool, they also would be appearing as objectors here today. But given the process taken, the submitters have ensured that these neighbours weren't aware they will be directly affected by these proposals. And as a result of a submission which has been deliberately vague in its extent, there are directly affected property owners who are feeling disenfranchised and are unable to comment or speak to the panel. As regards the site viability, I'd just like to point out that our property at 1137 Springs Road is strategically placed in the middle of the rezoning proposal land parcels. The outline development plans show where key infrastructure is located. The plans show stormwater basins, secondary flow paths, roading, cycleways on our land. Unfortunately, because the submitters have failed to take into account our expressed long-term plans for our property, the ODPs will not be able to be implemented as they stand, as there will be no accommodation of any development or infrastructure through or on our property. This is particularly problematic for the submitters should the medium density residential component be rejected, as the industrial ODP would be split into 2 portions by our property with no available stormwater flow paths, roading or cycleways to link through the industrial zone. Due to the impediment our position presents to developing the site, the rezoning proposal and ODPs are simply not workable, are not sound planning propositions and therefore need to be rejected. In closing, I would like to invite the panel for a visit as part of your decision-making process to gain an understanding of the land and the manner in which it is being productively used. Thank you for the opportunity to speak today.
No, thank you very much. Raymond, questions?
But thank you for your very informative submission. I appreciate it.
Thank you.
Andrew.
Yeah, thank you for your submission. I thought the maps were extremely useful. I just have one question. I'm just interested. So you said you're still farming the land, and you talk about, I think, cropping and stock. What size is your site?
As is 13 acres, 5.6 hectares.
5.6.
Yeah, and we have a small Suffolk stud.
Yeah. No, I'm just interested because we hear a lot of people tell us that it's hard to productively utilize sites, of that size, and yet you are using it and you can. So that's just interesting. Thank you.
I would like to make the comment. We've had this discussion a lot.
Yeah.
There are very few farmers nowadays whose entire income will come off their farm anyway, whether that's 100 acres, 500 acres, 13 acres. We intensively farm that block. We have lucerne, we have Coxfoot hay, specifically for horses. We have a walnut orchard, we have a stud. We intensively, as much as we can, farm that block. And I think if you were to come to site, you would see that the majority of those landowners are intensively farming those blocks.
Okay. Right, thank you.
What's your day job?
I'm a landscape designer, actually.
Yeah, I'm just interested because this is probably a good example of what I would call layperson evidence. It's of a very high standard. So I just was wondering what you actually do for your day job.
I've worked for councils, not in the proposed plan sort of area, but I have worked for councils for 25, 30 years.
Yeah. All right, well, so that was just a matter of interest, but look, your the document you've tabled today is extremely clear and you've outlined your concerns very clearly. So there's no questions of clarification that I have for you, but thank you very much for preparing your document and for coming in this afternoon.
Thank you.
Thank you. My microphone off. So now we're going to adjourn. We're back on afternoon tea time, and we have two remaining submitters for the day, Lincoln Voice and then Rolleston Industrial Developments Limited. Yeah, good afternoon, everyone. We will reconvene hearing number 8 for variation 1. We were dealing with rezoning proposals in Lincoln, and at this stage we're hearing from Lincoln Voice Incorporated. Denise Carrick. Yeah, of course. Yeah, come up to this table where the microphones are. So again, good afternoon and welcome. I think you've appeared before us, I think at least one time before, but I'll just repeat what I say to all submitters. Thank you for preparing the written material, which has been pre-circulated, and we have your 24-page statement, which we've read, so you don't need to read that out loud to us.
No, that's
But
good.
of course, you are very welcome to either summarise that or outline key points for our benefit, and then we'll see if we have questions for you. And if you're and want to introduce the other people, if they want to say anything, they can as well.
Okay, Tēnā koutou. I'm Denise Carrick. I represent Lincoln Voice, and I've got, do you want to speak?
Sam Carrick. Oh, sorry. Yeah, Sam Carrick.
And also, we're all members of Lincoln Voice, and we have some other people supporting us here as well.
McGlinchey, MC. On mute. McGlinchey, is that better? MCG LINCHY.
Yeah, so we're representatives of Lincoln Voice, a Lincoln-based community group. Thank you for your time in hearing our case today. We appreciate we could probably come across as a bit of a bunch of whinging locals, or we sort of feel a little bit like conspiracy theorists, but honestly, we have no interest or time for any such things. We are just concerned residents focused on a fair and democratic process. Our written statement of evidence sets out the concerns we have raised around the inclusion of the PC69 land in variation 1. And the concerns that we have that PC69 land is not being evaluated under the MPS HPL. We have also raised concerns about the considerable implications this has on other submitters' urban rezoning proposals being fairly evaluated under the MPS HPL. Our statement tries to summarise the numerous issues around and arising from the council decision to include PC69. We are not intending to go back through those today. There are just too many for the time available. The intent of our statement is to summarise and raise as best we can our interpretation of the full context around the background and issues of including PC69 in variation 1. We also recognise that by the firmness of the attempted rebuttal by the PC69 lawyers, that we must have raised some meritorious questions for your consideration. Appendix 2 of our submission contains the letter from the Council CEO to Lincoln Voice members dated 4th of July 2022, responding to the open letter signed by more than 240 residents in Appendix 1. The CEO states, Council's legal advisor did point out that the PC69 process was not completed. I repeat, the CEO put in writing to us, the Council's legal advisor did point out that the PC69 process was not completed and that the Council's decision is subject to appeals to the Environment Court. The Council, while acknowledging that some costs will be involved, considers lodging appeals to the Environment Court is the appropriate avenue for those submitters wishing to test the decision. So for those reasons, the Council decided to follow and respect the RMA statutory process provided for plan changes, which includes for those who wish to challenge the decision an appeal process. This is the actual written words of the Selwyn District Council CEO to us. Within 3 weeks of that letter, the council staff then advised the councillors that PC 69 should be included in variation 1, based on the rationale that it had been through a complete Schedule 1 process and it made convenient planning sense to use the IPI process to get a coordinated planning document sooner rather than later. As you would have read in our statement, this has become an increasingly complex and confusing situation through a compounding set of actions by Selwyn District Council. We would like to make it clear that none of this complexity is of our doing. We have consistently acted in good faith. We lodged an Environment Court appeal as recommended by Selwyn District Council. Numerous community members donated to support this appeal, as well as both the Environmental Defence Society and the Environmental Legal Aid Fund, seeing merit to commit support and funding to that appeal. Our position has been simple and focused. We are trying to stick with the principles of plain and ordinary meaning. Simply put, our case is that PC 69 land is on some of Aotearoa's best food producing land. There are far better alternatives to enable housing that have lower environmental impact, less publicly funded infrastructure requirements, and are better for reducing our climate change impacts. Because PC 69 had not been made formally operative by the time the NPS HPL became operative, then it should be subject to evaluation under the NPS HPL. This is the heart of our Environment Court appeal. The inclusion of PC 69 in variation 1 muddied the waters considerably. If this turns out to not be a mandatory decision, then our community members really question why the council, who are a public agency, recommended we should take our case to the Environment Court. The very people who are one of the guardians of the resource management process and charged with protecting highly productive land. Why would the council push so hard for the situation that we face today? Our advice from the Environment Court was that questions on the inclusion of PC 69 in variation 1 may not be able to be addressed by the Environment Court. All parties agreed to put the appeal on hold, to be able to raise these questions at this hearing for your consideration. There was also the risk that variation 1 process would be completed before our Environment Court process was completed. It therefore did not seem morally right that we risk spending considerable public funds and community donations with such high uncertainty and risk that the variation 1 process could make the heart of our appeal essentially moot, null and void, which is what we were told. We would like to conclude by raising our position on the question of judicial review, which has been mentioned as another avenue to pursue. The reality is that despite the advice we have received regarding the potential merit of such a case, this is both a very costly and risky path for a community group like us to take, particularly the risk of being subject to having costs awarded against us should we lose. It is unrealistic to expect a community group to pursue this avenue. Thank you for reading our statement and for hearing us today.
Thank you. I'll see if we have any questions for you, Raymond.
Thank you, Mr. Chairman. No, I don't have any questions because what you provided was very clear. So thank you for that. It stepped me through all the issues as you see them, provided all the background to that. So thank you for that.
You said, in terms of your appeal on change 69, you said all the parties have agreed to put that on hold. When was that decision, or when was that agreement reached? Can you remember?
Don't have the exact documents on us today, but
Roughly.
it was prior to Christmas 2022, so it would have been early December when those.
So December last year.
Yeah,
Right, okay.
I don't remember when the
Yeah.
judge sent out their their decision, but
Christmas.
obviously it was before that. It was early December was probably fair enough to say.
Can I add that the impression by the Rolleston Industrial Developments has been given that we requested that pause. That's not quite true. It was more of a mutual agreement because of the advice that we received to that point.
Yeah.
And also, it's probably important to know that when they were considering whether to include PC 69 into the medium density rezoning process, we did submit and ask that they not do that because we expressed concerns that this very situation would arise, that our case would be detrimentally affected.
And right at paragraph 2 of your statement, you say the central focus is that PC 69 is located on highly productive land. So I take it that is your main concern that you're wishing to bring to our attention. It's the highly productive land issue.
Yes, that's the
Yeah.
as we said, that's the heart of the appeal and the in the critical issue here on that sense. In the heart of our case is that it should be evaluated under the provisions of the NPS highly productive land in that set of comparative tests it does in terms of other options.
Yeah, I understand that.
Yeah.
All right, but like my colleagues, I have no questions, clarification, because as they've said, your statement is very clearly set out and it goes through in a lot of detail, which we've read. So having read that, I think I understand what you're asking us to consider and the reasons for that. So there's nothing that I wish to clarify with you. So don't be concerned about that. I mean, we ask questions if we don't quite understand what submitters are telling us, or we need to clarify things.
Great.
Thank you.
Right.
Yeah.
Thank you.
Thank you.
Now, our next submitter is Rolleston Industrial Developments Limited. Are they here yet? I see you're here, Mr. Carter. Is your team arriving?
I got a tick before saying they're occupied.
Yeah, so we'll adjourn while you do that, and we'll just wait for your team to arrive. All right, good afternoon. We'll reconvene hearing number 8 on variation 1. We're at this stage, we're considering rezoning matters in Lincoln, and we now have our last submitter, Rolleston Industrial Developments Limited. Good afternoon and welcome.
Thank you. And just putting the emphasis on the word last submitter, I think this is my last appearance. So I just thought I'd take the opportunity of thanking the panel for this panel and the proposed plan panel for their patience and assistance over the last period of time. So, and good luck with your deliberations and finalisation.
Yeah, thank you for that. There's a bit of work for us to do yet, but we can see the light at the end of the tunnel.
Thank you.
So now I think we've indicated to you that we had no questions for your technical witnesses
Yes.
because it's the same material that we've
Yes.
reviewed previously.
Yes, and this was you recall the matter where because the land in question was included in the council's variation as an MRZ zone, and because it was therefore in the scope of the variation, that the relevant section 42A report is actually the residential chapter rather than the Lincoln chapter, but we had indicated, because we were aware that Lincoln Voice in particular had some things that they wished to say, that we would come here to this hearing again. So I was going to deal with some points that Lincoln Voice had raised really, and I have listened to them on YouTube on the way out. So I just had a couple of points. But just before I do that, the panel will be aware that I had reserved the right to cross-examine Mr. Yeoman in relation to the parts of his report that relate to Lincoln. And the fundamental submission that is made is that in light of the criticisms that Mr. Akehurst and Mr. Colgrave have made in relation to the modelling, that notwithstanding the council do want this land residentially zoned, that they have underestimated effectively the need. So the need is more than what Mr. Yeoman would say it was. I don't need to cross-examine him unless the panel are wanting to explore any issues with him and I want to pick anything up from that. So I was going to give him the opportunity first, or the panel the opportunity first, of explaining what relevance his report is to this land, and then in a particular capacity issues, and then only if the panel had any questions picking up after that, rather than launching into a line of questioning, which is not going to be helpful or of interest to the panel.
Well, it's interesting you say that, and I'll come back because we have in front of us legal submissions, I think, from you, or we received from the officers legal submissions from you dated 21 April and 26 May.
Yes, so the 21 April ones were the residential chapter ones, and the 26 May,
So maybe if we have questions from those legal submissions, and then we'll deal with that. The Mr. Yeoman
I might
issue.
just make a couple of comments, and just listening to Lincoln Voice on the way out here. The question of whether the council should not have included the Lincoln South land in Part A of its variation as a new residential zone, or varied PC 69, which is Part B, which is a variation to the operative plan, is in my submission a question that could only be determined by the High Court. This very issue was put before the Environment Court as part of one of a number of preliminary questions that Lincoln Voice would have liked the court to answer. And at the pre-hearing conference we had on that matter, Her Honour Judge Borthwick indicated that she did not consider she had jurisdiction to deal with the issue of whether the land should have been included as a new residential in Part A, or whether it should have been varied under Part B. So she certainly doesn't consider she's got jurisdiction, and I think it's pretty clear that this panel does not have that jurisdiction to determine that issue. The issue of the interpretation of the MPS HPL and whether this land is exempt, notwithstanding that it does clearly have class 1, 2 and 3 soils, was also raised as a preliminary question, and Her Honour was prepared to deal with that as a preliminary question, which we actually thought would have been actually quite a useful exercise for this panel. But Lincoln Voice elected on 12th of December in an email to adjourn those proceedings. The previous submitter is correct that we then 7th of December, they decided to adjourn the proceedings. The submitter is correct that we then filed a joint memorandum with the court agreeing with that course of action. but it certainly wasn't initiated by us. And then the third preliminary question is one that this panel is grappling with, and this is the interface between the MPSUD policy 8 and what that means. So none of those have been determined by the Environment Court, and one of them, as I say, would need to be determined by the High Court.
Yep.
So that's the fundamental point. The other point I would make, however, is that PC 69 appeal remains live. It's before the Environment Court. And the Enabling Act makes it clear that whilst there is no appeal on the variation to PC 69, so this is just dealing with the operative plan, that does not affect the appeal that the parties have to the underlying plan change, which is live in front of the Environment Court. Yeah. I think the more practical issue is, however, that as with all the plan changes to the operative plan, they're going to largely fall away when decisions are made on the proposed plan. So that becomes a practical issue rather than so much an issue of natural justice. And what parties do with the proposed plan is a different issue. So the PC 69 appeal remains live, remains in front of the Environment Court, remains able to be taken by Lincoln Voice to the Environment Court, and whether there's practical futility in doing that or not is a matter for them. However, the other point that I would make is that we have had the proposed plan process, and that involved Carter Group seeking the rezoning of the land at Lincoln South, and parties having the ability to come along and put evidence in front of the panel, opposing the fundamental shift from rural to residential, and no parties provided any evidence. And in this process, Lincoln Voice in particular, because council have proposed this as a new residential zone, have had the ability to come along, make their submissions and put whatever evidence in front of the panel that they wished. Now, I do accept that the MPS HPL exemption argument raises the issue about whether the provisions of the MPS apply or not. But beside all of that, it's undisputed that the land contains LUC class 1, 2 and 3. Versatile soils were and are an issue at PC 69 regardless of the MPS. We had expected to see a full suite of evidence produced here for this hearing, setting out on merit-based why Lincoln Voice considered that this land should not be rezoned for residential. And they have chosen not to do that, notwithstanding that they've had the full ability to present their full case before this panel. So why they've made that decision is a decision from them. For them, we are surprised though, because they did put the full suite of evidence in opposition before the PC 69 commissioner, and we'd expected to see that rolled out here, but we haven't. So I would just chafe back against any suggestion that there's been any sort of breach of natural justice and they've been denied any ability to come before the panel with merit-based evidence to say why this land shouldn't be rezoned. And then the final point that I'd make is that this is not, you'll know from other hearings that I've made some submissions about scope of the variation and whether submissions seeking rezonings outside the boundaries of the notified variation are in scope or not, so-called Me Too submissions, and Carter Group have chosen not to proceed with some Me Too submissions, in particular in Rolleston. This one's different because this is the council notifying a new residential zone, and we are simply supporting the council's position. So this is not a rezoning submission. This is support of the council. And where we thought we could lend support was just to bring that extra little bit of evidence that was needed to get the panel from GRZ under the proposed plan process, or PC 69, whatever that zone is called, and operative plan, to further intensification, which is why we limited our evidence in support of council's variation just to dealing with the intensification aspect. So that's really what I was going to say in addition, but I'm happy to answer any questions on the legal matters.
Right, we're just referring to your 21 April and 26 May legal submissions that we've been pre-circulated. I'll see if we have any questions arising from that.
No, No, but I just, not as such. I just do have one question, and I think it should be, I think I'm clear, but it's just clarifying. So as I understand it, there's an appeal on PC 69, which is to change the operative plan. I understand that, and that's on hold. A panel, one of the panels will make a decision on the proposed district plan zoning.
Yes.
That is appealable and may or may
Yes.
not be appealed. And then the decision on the MDRS application is made again by the IPI panel, and that is not appealable.
Yes, so.
And then what happens?
So on part A, that is the council initiated new residential zone. So that is not appealable. Part B is the bit which varies PC 69, and that is not appealable. But somewhat strangely, the underlying PC 69 does remain on appeal. So that, yeah.
Yeah. So what is the practical upshot of all
I suppose
those decisions coming out?
Yeah, I suppose the practical upshot of that is that the decision on the proposed plan, if it's not appealed, and Lincoln Voice, for example, are not a submitter in that process, and or the decision on part A of the variation, which is a variation to the proposed plan, which is not appealable, is probably practically going to drive the decision by Lincoln Voice as to whether it's practical to carry on with their appeal or not. But that's a decision for them. And that's going to impact all plan changes. So it's going to impact all plan changes that are on appeal if they're overtaken by a decision on the proposed plan.
Sure. So okay, so PC9's appealed. So assuming if the PDP decision was to again carry over or approve that plan, that change as well to residential, and that was appealed, and then the panel made a decision, the IPI panel made a decision approving MBS provisions for the site, and those other two, what happens? They just drop away. They're no longer relevant, basically.
So I think in this particular circumstance, because it's not a Me Too submission. So if I could start with, if it was a Me Too submission, the underlying proposed plan to go from rural to GRZ would be able to be appealed by anyone to the proposed plan process. And then the IPI bit of that variation, if you like, the Me Too submission, is still going to be susceptible to being undermined, even though it's not able to be appealed by appeal on the proposed plan. This one is different, however, because the council have chosen to include the land as a new residential zone in its variation, and that is not able to be appealed. So I suspect that this decision on that part A of the variation practically is going to take care of both the proposed plan appeals and the PC 69 appeals in a practical sense.
Well, that's what I understood. Thank you.
No questions for me arising from the pre-circulated legal submissions, but thank you for doing that. Just turning to the cross-examination issue, I was going to ask you a series of questions about that, with my understanding that the cross-examination should be designed to assist us in making a decision. And I was going to say to you, in this case, PC 69 has been zoned MRZ by the council.
Yes.
I'm not aware of any recommendation coming through from the officers to overturn that. There was the live issue of the local centre zone versus the neighbourhood centre zone and the supermarket issue, which we canvassed in full in hearing one, and we asked Mr. Akehurst some questions about that, and that hearing one IPI panel will deal with that matter. And the formative report that Mr. Yeoman authored, my reading of that is that it included the PC 69 in its assessment of feasible supply. So I was really going to ask you, how would any cross-examination of Mr. Yeoman help us make a decision?
Yeah,
and
no, so
I couldn't see an answer to that.
Yeah, so if I could just cut to the chase on that, yes, Mr. Yeoman has this getting over the line as needed, but we wouldn't want the decision to say it's needed based on necessarily on his numbers. So I think we would want some sort of statement to say that his assessment is at least conservative, to allow the challenge somewhere down the track for, well, actually more was needed than he thought. So we would say it's an underestimate. It still gets over the line, but we'd say it's an underestimate rather than an overestimate. And we just wanted to be careful about any findings.
Yeah.
So I suppose what we'd say is it gets over the line by more than what he has it getting over the line.
Yeah. Relying on the evidence of Mr. Colgrave and Mr. Akers
Yes.
that we had
Yes.
presented to us at the previous hearing.
Yes.
Which we've read and understood. So.
Yes. Yeah.
All right. So I don't think we would want to ask Mr. Yeoman any questions. We understand the situation. So do you wish to cross?
No, as long as it's just that right away, except that he accepts it gets over the line, but we think it gets over the line by more than what he says.
Okay. So, all right. Well, that's good then. So I think that brings us to the close of the day, unless there's anything you want to add.
There's just one more. So we had filed some legal submissions on behalf of
PG
PG
rights.
yeah, and it may well be there's not any questions, but Ms. Forrester was going to deal with that issue. Yeah.
Forrester. So
Well, so we
this is
just
your
tabled
moment.
some legal submissions, just opposing the Townsend rezoning, very much on the same grounds of the ag research plant and food, reverse sensitivity grounds, and they provided their own evidence as well. So kind of coming in support of that and just providing a further reason.
Yeah, thank you. We read that pre-circulated material and that was helpful. I think we'd indicated we didn't have any questions for the PG rights and material, but I'll just double check. So Raymond, any questions? No, I didn't. It was very clear. So no questions, and it was very consistent with what we'd heard from other aligned submitters that you mentioned.
Thank you, Commissioner.
Yeah, so that's all good. All right. Thank you. So that brings us to the end of the proceedings for today. So thank you very much, everyone. We next convene next week on Tuesday morning to deal with the very last matter, which is the Prebbleton rezoning matters under variation 1. Thank you.